if it was a normal land acquisition,
that assistance argument may not apply. You had done the calculation, you had given them, the interest was to be paid. They did not pay. They will this issue about 47,
we did not.
52, 72,
This
or 127.
This had to be brought to honorable court's notice, but we went about it as if it were to be a regular land acquisition issue. Under land acquisition law, my lords, when any improvements have been undertaken on any of the lands that are acquired, they have to be quantified. So they have adopted that procedure. Whereas this act is a special statute, it's a self-contained code. There is no opportunity for one to look beyond the statute to assess compensation. That's why, because statute, my lord, my humble submission is they have not used the word compensation at all throughout the statute.
Can you have a different calculation for the same landlord,
Please.
for the same lands?
What happens, my lords, if they follow the Land Acquisition Act? There, yes, my lords, we had to go through that. But where they misdirected themselves, they did not realize the mandate of this statute under Section 47, the limit placed under Section 47(4), Section 127 capital A, and Section 52. That was totally overlooked. If that was brought to the notice of the honorable court, my lords, then we wouldn't have suffered such an order. And further, my lords, by the time we realized the mistake, contempt proceedings were initiated against us. Under the threat of contempt is when we made the deposit.
And we are not enamored by that argument of contempt, threat of contempt. So you did not do something. That's why the contempt. There's no threat in contempt.
No, but that is how things transpired then.
You require contempt to make you move. What to do?
Can be no estoppel against statute. In fact, statute has to be applied in its fullest force because that is the mandate of the law, that is the legislature's intent, and this has been upheld by my lords and the apex court and the constitution bench. Further, my lords, with regard to the other that they've made, the lands that have not been taken into consideration, because Section 47 clearly says a land loser and the lands vested. So the plural, the land loser could have just 10 acres, could have 10,000 acres, all of them different land parcels. All of them put together is what this compensation is determined for. It does not go by extent of land alone. It goes by the income, because the section talks about land revenue talks about annual income. Compensation is determined by annual income, not just the extent of the land. Extent of land is incidental, because the akar, the revenue is assessed based on the extent also, not only just the quality of land. So the income is what is determined. Income is what is the determinate factor when deciding compensation, not the extent. So whether it is 3,000 acres or 4,000 acres, the total income that could be derived from the property is calculated and disbursed already.
Yes.
In accordance with the statute. So, my lord, even if the portion, if according to them, a couple of 100 acres were left out, it won't change anything. The math will not change simply because there is a cap placed by the statute.
Of 2 lakhs.
That is one point. Second thing, my lord, second point, even if it were to be said that those lands have to be looked at for the sake of compensation, that again, my lord, will have to be done in accordance with this statute, not the principles which they adopt. Because once the learned senior friend produced a judgment which applied to land acquisition legislation, well, that form of assessment and the interest that is applicable to lands that are acquired under those statutes will not apply here. Here, what is the annual rent that is recoverable? Annual income, which is 10 times the annual rent. Lords, the assessed value from that day till today is one and the same. So if even today, if it were to be calculated, my lord, for the 300 acres, I can give provide the math, my lord. I'm sure it will not cross more than 50,000. And they have already enriched themselves with more than 1.5 crore by now.
According to you now.
Yes.
Yes.
Because improvements, even towards manner in which the competition 47.3 says where there are wells, other structures, including structures like fund, of a permanent nature on the land, constructed by the landlord, value thereof calculated in a prescribed manner of the payment. Then comes the fourth. Notwithstanding any complaints in subsections 1 and
My lord, may I disturb my learned friend's arguments, my lord? Uh, it's just the connection is getting constantly I've not been able to follow my learned
Can
friend's
you
argument.
speak in the mic?
No, my lord, the connection is getting completely. I can't hear my lord, neither can I hear my learned friend. The connection is very bad, my lord, from the side of the court, unfortunately. Just see.
You can hear us now, Mr. Jaikar?
Well, now I can hear, but the earlier part of the
Yes.
arguments I can't hear, and I couldn't hear at all. I'm sorry, to my learned friend. If he can just repeat that, if hello,
47 clause 4 takes into
yes,
consideration both clause 1 and 3.
yes,
Notwithstanding anything in subsections 1 and 3, the aggregate amount payable according to
correct,
subsection shall not exceed rupees 2 lakhs.
yes,
So not only the value of the land as determined, the method of compensation clearly indicated, even the improvement, which could be sinking a well or putting up bund or any other kind of improvements, permanent structures put on the property, the maximum all of them put together in all the lands lost by a landlord is 2 lakhs. What is the purport, import, and the mandate of this particular section?
Seems pretty draconian.
It's echoing.
Seems pretty draconian. Any
Draconian.
judgment or no judgment on this provision at all?
Idರಲ್ಲಿ the same.
47, there's no
So the
judgment.
entire statute was challenged on the main reason, but the compensation determined is illusory.
This is a different. 47, there's no judgment.
Precisely on this now. One single learned single judge's order, my lord. I think I can place that on record. On the first day of hearing, I had got it, but now today I don't have it.
Is there any judgment on
And they have referred to the judgment of the AP court, and they said that it is constitutionally valid and compensation has to be determined and disbursed in accordance with the limit of these provisions. Should, I think deliberately, so that there is no such confusion that they did not want the statute to be confused with other land acquisition statutes because there is no land acquisition by the state at all under this statute. Hmm. Discrepancy I have furnished in land parcels which are not taken into consideration should be on the same. And the 18% interest that they have claimed, that is one of the arguments that they take. There is no provision to pay interest in this act prior to the date of vesting. After the date
start that again.
of vesting, and the date of disbursement of compensation, any discrepancy in that, my lords, then they can make out a case. I have to be fair to me. Outside the suppression they have placed before my lords, before the land tribunal. Proceeding presupposes that there was a disbursement of compensation because the land tiller, the tenant will not get the occupancy rights unless he's made that payment and the payment is transferred to the land. Please. So that aspect, my lord, I think was not placed on record either by the state or the petitioner. So my humble submission is, my lord, presupposes there is a question of overlooking any particular land can be ruled out. Then what is my humble submission? This
What happens to this 818 acres?
that
If there are
also
no documents. Yes.
Once again, Millard, I
no,
have
we have placed. That is my submission. Honorable Court. Now 11 more because these are all date back to antiquity almost. So we have found 11 more survey numbers for which there are documents which show.
Yes, they're mentioning more 11 survey numbers in their disclosure.
is my
The
learned
total now the total extent, the difference in area would be around 600 acres.
What was Jaikar's argument was 818 acres are missing.
Yes, yes, Millard.
Correct, Ms. Jaikar?
Yes, Millard. 3,118 on their own showing was the total extent of the land, and what I've been paid for is for much less. That's what I pointed out.
Differential is 818.
800, yes, Millard.
Even if
800
we
now
take this
because
into
I'm
account-
furnishing this information. Now the difference would be 600, not 800. 600.
So what to do
It's
about
not any
600?
less. I bowed on.
What to do about 600?
I just want to be a little more precise.
Even if you succeed in assuming that you
If they
succeeded
succeed in this-
argument number 1,
Please,
we don't know. If you succeed in argument number 1,
please.
that won't help you in this differential.
No, not at all, my lords. Not necessary. I bow down, please. If I am able to demonstrate and convince my lords that regardless of the extent, even if this 600 acres or 800 acres are added, this is the maximum that they could have obtained.
Not the proceedings under 47.
Hmm.
You could not take possession if the proceedings have not happened in
Look,
74.
the proceedings have happened. In case, hypothetically, please.
That is why we are asking you the calculation of it.
No, they also don't dispute that they have lost lands because they were given over to tenants. Their only case is that, my lords, my lands have been taken away, but I have not been compensated for those lands. That is their case. So they do not dispute vesting of land and the lands having been given to tenants, the particular tenants in those particular land.
Well, sorry for my learned, I'm disturbing in. My contention is, my lord, that the lands that have been taken are lands for which I've been paid, which is shown in R1. But other than R1, there are lands. So now those lands have not been taken. Those lands have not been paid for.
No.
Because other than R1, there is lands. There are lands.
No, I think.
That's why we are asking you that.
No. Lands, they do not. If lands have not been taken, they wouldn't be asking us to pay compensation, my lords.
But because
See their prayers that they have sought for. Please see the written submission also and the argument that were advanced with your make out. Is that they're saying you should not interfere with the use of 818
ಅಲ್ಲ,
acres.
ಅವ್ರು ಹೇಳ್ತಿರೋದು ನೀವು possession ತಗೊಂಡಿಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅವರು.
And with respect, my lord, there is no reply from my learned friend to that application of mine.
That you made very clear.
No, my lords, we were made to understand that there are some lands which have been taken and they did not find mention in the list that we provided. And for that, they were seeking compensation. But now, if they're taking a stand saying that those lands were not taken at all,
Taken both the contention.
in case as an alternative.
6 months ago, you said you have all the records. Then Mr. Jaikar said we'll go inspect it and see it. That's why you got that 6 months. We've been back and forth on this. This
Lord,
was what was supposed to be done.
No,
in
lands
6
have been
months.
taken, my lords. Lands, my humble submission is, lands have been taken. They've already been dispersed.
Show us some documents if there are.
Lords, tenants.
We'll have to deal with it separately, right?
Form, they're registered. Tenants. Tenants. Certificate ಕೊಡ್ತೀನಿ. ಸಾಗುವಳಿ ಚೀಟಿ ಅವೆಲ್ಲ ಕೊಡ್ತೀನಿ. ಇದೆ, ಕೊಡಿ. ಆ ಸರ್ವೆ ನಂಬರ್ ಕಲೆ ಇದೆಯಾ? ಎಲ್ಲ ಸರ್ವೆ ನಂಬರ್. We have it on. We have it, my lord. I'll place it on record. I'll furnish a copy to my learned friend. The possession, the fact that these lands are vested with the state, there is no dispute, my lords, according to me, because the lands with regard to that, I have.
Saying it is not in dispute. They are disputing it. That's their
I'll place
argument.
it on record. I'll place it on record.
Again, Mr. Vijay,
Allah, I bow down, my lords. We were not aware that they were under the impression that their lands were not vested at all.
Please see the written submission. Please see their argument. Why is this like
ಅಲ್ಲ,
this?
ಅವ್ರು ಏನ್ ಅವ್ರು ಕೇಳಿರೋದು?
Nobody really.
Or they were saying that they should be reevaluated and they should be paid compensation as on today because they left
They're
out.
compensated, or let me use 818 acres.
No, that they could.
Without interference is what they're saying. It's not vested with you is what their contention is. That is what the reconciliation was.
Extent for which compensation has been paid, not with regard to
When
vesting.
will you place this on?
I'll place it tomorrow, my lords. Tomorrow itself.
Heard further arguments of Sri Vijay Kumar and AG relist on 24th.
Please,
Place it, serve it.
please. I'll share it with the learned senior friend also. Please.
Don't, that day, please don't.
No.
If
Please.
anything is not there, it's not.
No, I will not argue, my lords. I'll place it on record and I'll wind up. Please. Obliged.
Obliged.
Serial number 2, Ravi B. Patil.
So appears, nobody appears from Kalburgi for the state.
I'm sorry, my lords.
At the request of the,
I beg for my lord's forgiveness, my lord.
at your request, 24th.
Please. Obliged.
The request of the Additional Advocate General relist on 24th.
Please.
So you are coming that day, please close
Please,
this.
I'll appear in this matter too. Obliged.
230 matters. List number 2, pronouncement of order. Serial number 1, Sumati.
In view of all the above, no grounds being made out, the writ petition is dismissed, reserving liberty as aforesaid.
Serial number 2, Vinay N.
The writ petition is allowed, certiorari is issued, the impugned order dated 15/7/25 at Annexure L passed by respondent number 3 is quashed. Respondent number 1 is directed to, within 15 days of receipt of a copy of this order, appoint a suitable person as administrator to take charge of the affairs of respondent number 3, who shall act in terms of subsection 3 of section 27A and in terms and subsection 4 of section 27A. The administrator shall take all necessary action to convene the general body meeting of the society after enrolling all clerks across the state of Karnataka and hold elections for the constitution of the governing body. The enrollment process to be completed within 16 days from the date of appointment of the administrator being completed. Though the above matter is disposed, relist on 27/11/26 for reporting compliance with the enrollment process. Enroll everybody. Enroll everybody.
Please.
Then they will give you the money also.
Our worry is only money matters.
Your worry is only the money.
Insofar as matters, welfare fund matters, I'm not talking.
Enroll them. They'll give it to you.
Serial number 3, Dilip Kumar Gowda.
This morning you are submitting that there's a reference made.
Please, on 14.
That won't have any bearing because we have held that without a reference being made also, in view of Sayali Joshi,
Please.
the suspension could be done.
Please.
But we have set aside the suspension because there was no aid and advice. The writ petition is allowed in part. The impugned order of suspension dated 10/7, and actually they had not challenged the reference. Though 2-3 times we mentioned you did not. Writ petition is allowed in part. The impugned order of suspension dated 10/7/26 bearing number so-and-so passed in purported exercise of power under Article 3172 of the Constitution of India and communicated by respondent number 2 is quashed. As a consequence, respondents are directed to reinstate the petitioner as the chairman of the Karnataka Public Service Commission within 7 days of the receipt of a copy of this order. The petitioner on reinstatement is entitled to function and officiate as the chairman of the Karnataka Public Service Commission. and is entitled to all consequent service and monetary benefits flowing from quashing of the order of suspension. The petitioner is, however, restrained from taking any decision or act or causing anyone to act in any particular manner in respect of the action proposed to be taken by the Commission against his daughters. It is, however, made clear that this judgment decides only the constitutional validity of the impugned order of suspension and does not decide one way or the other the truth or otherwise of the allegation against the petitioner and or his daughters. It will be open to the competent constitutional authorities to proceed afresh, if so advised, strictly in accordance with the Constitution and the law declared in this judgment. That is, on the prior aid and advice of the Council of Ministers, that an order of suspension under Article 3172 can be made. All pending application, if any, stand disposed in terms of the above.
Lords, please.
Serial number 4. Connected matter.
Yeah, for state, my lord.
Yes.
10-8 order, my lord. For complaints of 10-8 order, my lord.
Huh.
Lord, may request, my lord, to have it on 20th.
The list of all the tanks and everything.
Tanks.
List of all tanks, my lord. We are doing it.
And AG6.
Milord, I request Milord, 4.2 is concerned. The entire list, Milord, I verified. Bangalore South Taluk, Milord, my tanks are not included. Therefore, Milord, my writ petition
Can we
be
do,
disposed of.
so we'll delink yours and post it to December?
No, not dealing, Milord. It
Can't
can
be
be
doing this
disposed of.
when matters are being
Because
taken up together. My matter is different, Anta.
my tanks are not included in that list which are being handed
You can
over.
argue it when they face the affidavit. And AGS seeks for and is granted 10 days time, a week's time to comply with the order
20th, my
dated.
lord. Could it be taken on 20th, my
What is the
lord?
order dated?
10-8, my lord.
10/8/26. Relist on 20.
Sit down for
August.
Melada. This is the season for fish breeding in Melada. I am the successive bidder in the tender process. Melada tender process has been completed.
Do one thing, you make the list and give it to us. ಅವರು ನನ್ನ ಸಪರೇಟ್ ನಿಮ್ದು ಇದು ಅಂದ್ರೆ ಲೆಟ್ ದೆಮ್ ಮೇಕ್ ದ
Sit
ಲಿಸ್ಟ್.
down for that Melada.
28th August.
The interim
number
order may be
5.
the interim order.
Interim order.
Great.
Serial number 5. Please wait.
Chip, on the last date of occasion, my lordship directed me to bring out certain facts as to how he was involved in the crime, this ED matter. Lords, I have to secure the RUDs which are available for this case. If my lords remember this,
Transfer of SS Enterprise, Cynet Enterprise.
please. So I must submit, my lords, the officer was transferred, so I'm getting the RUDs to substitute.
When?
Wednesday, I mean Tuesday or Monday, any day, my lords.
The Council for Response seeks for a short accommodation. Relist on 25th.
25th,
Tuesday, 25th.
25th, we have the Genpact matter, my lords. If maybe on Monday.
27th.
27th.
Not been granted till now. Then after hearing.
Please, obliged.
Serial number 6.
Then discharge ಆಗ್ಬಿಡ್ತಾರೆ. They'll be acquitted only. Looks like they were arguing.
ನೀವು ಸುಮ್ನೆ
Excuse me for Victor Per for petitioner Melada. On my part, Melada, I find my brief argument Melada written on.
Sorry.
Copies have been served to other side.
Yes, Mr. Ravishankar. ನಿಮ್ದೆ ಅವ್ರದ್ದೆಲ್ಲ ಮುಗೀತು.
Lord, 3 submissions, quickly. Kindly see the prior, man. Ink page 26.
Yes.
Share it, so in the name of squashing, retender notification issued by respondent number 1. Respondent number 1 is the municipal commission, whom I don't represent. This is only with respect to the acquisition. First, my lords will get into the acquisition. Only if the acquisition is fine, then everything will follow. Kindly see the second prayer.
Where's Mr. Nagarajappa?
He's there, but since my lord said gone into all other aspects, it's okay. I myself will come. Kindly see the second one. declare the preliminary notification of 1990, final notification, all 4-1, issued by respondent number 1, that is CMC, which is wrong, it is the deputy commissioner, stands lapsed by virtue of section 24(2) of the right to fair compensation, so on so. Pass such other orders. First point for my lord's consideration is, he says that the final notification declaration at ink page 31, my lord may kindly see ink page 31. It should go because it is issued not under the old Land Acquisition Act, it is issued under the Karnataka Land Acquisition Act, 1884. Therefore, it should go. Kindly now see this notification, 15/3/1990, by 319. 1984 ತಿದ್ದುಪಡಿ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯ ಮತ್ತು 1961ನ ಕರ್ನಾಟಕ ಕಾಯ್ದೆ ತಿದ್ದುಪಡಿಯಾದ 1894ನೇ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಅಡಿಯ ಉಪಕಲಂನಂತೆ ಚಿಕ್ಕಮಗಳೂರು ಜಿಲ್ಲೆ ಸಾಲ್ಟ್ಸ್. So it is also issued under the, kindly see the declaration at annexure D, ink page 34. What I read to my lord's consideration is preliminary. Now I am requesting my lord to kindly see the final notification. Declaration, ink page 34, annexure D. So this is the main nucleus of their argument and the pleading. Line 3, ink page 34. 1961 ಕರ್ನಾಟಕ ಕಾಯ್ದೆ ಸಂಖ್ಯೆ 17ರಲ್ಲಿ ತಿದ್ದುಪಡಿ ಮಾಡಲಾದ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆ 1894 ಕೇಂದ್ರ ಕಾಯ್ದೆ ರಂತೆ ಮತ್ತು ಪ್ರಕರಣ 6A ನಂತೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ಮೇಲೆ. So it is not under Karnataka Amended Act alone, it is also under the Central Act. So the main fulcrum of their arguments pleading is based on an earlier ruling of this honorable court, which perhaps we did not assist the court. Court felt that this Karnataka amendment itself is now repealed. Where is the question of you acquiring the land under the repealed act? That was the analysis under which the entire notification of one particular individual who sought that squashing was allowed by this honorable court. Perhaps it's our mistake of the rescue.
Now, your condition is, though the preliminary notification had been issued under that act when it was in existence,
Both under preliminary and final, Central Act is enacted.
when the final notification was issued, it has been issued only under the Central Act.
Central Act.
And the Karnataka Act has not been taken into consideration. Because it was repealed
So
in the-
earlier, they have relied upon that act, and also this court has passed an order saying that the Karnataka Amended Act is repealed, and therefore no acquisition could have taken place. The learned judge who passed the order that both preliminary as well as final notification was also made under the Central Act. Therefore, the
Final
fulcrum
notification has been issued only under the Central
only.
Act.
So this was the main, the nucleus of their case is this. Somehow it got, and 1990 is the notification. Challenge is laid. Kindly see, there is 2017. There is absolutely no explanation offered why there is so much delay, latches. There is absolutely no pleading, no explanation that is offered. Kindly see the photographs that and the document that I have produced. This is the first submission. Land has been acquired, layout has been formed, distribution has taken place in terms of allotment to the site has been allotted. Houses has been constructed. There is nothing that remains.
The photographs of that.
Photographs, my lord, may I kindly see ink page 48, annexure R19. R19, I have produced a bunch of photographs. R48 to 52, my lord. 5-6 photographs clearly indicate, and that's not been denied. It is developed long back, much before he knocked the doors of this court.
Yes.
Second contention he has raised is that an earlier point in time, Our authority ourselves, we had said that we don't want this land.
Hmm.
We had passed resolutions on more than one occasion.
Hmm.
Government did not accept this. Government said, go ahead with this. The approval was given under the provisions of the Urban Development Authorities Act. So now the contention of the petitioner is that, look, you yourself did not want this land. So where is the question of you acquiring this land? We are only an ultimate beneficiary of this. It is ultimately the land acquisition officer and it's the policy of the state. So the state said, no, you have to acquire this land, and we acquired this land. And we did not acquire. Acquisition took place by the AC and we have developed it. And denotification did not take place at all. So therefore, repeatedly saying that our authorities did not express their willingness at an earlier point in time may not be of much avail to the petitioners at this length of time. That's the second point. The ruling of this honorable court, if my learned friend has produced this, this is the order, I don't know the page number. In the rejoinder, the order of this honorable court is produced as annexure S, page 12. In the rejoinder. Similarly circumstanced persons had challenged this, the same notification.
Hmm. Yes.
Page 15, para 2. Division bench of this court so and so has held that the Karnataka Land Acquisition Act 61 was non-existent, being impliedly repealed with the commencement of Central Act, and further held that Deputy Commissioner who issued the notification under Section 4.1 subsequent to Central Act 18
That order had been intact.
complete amendment.
So it's insofar as the petition lands.
Concern. Point number one. And number two, my lords may kindly see, I just pointed out to my lords, it's a Central Act also that is committable. This was not brought to the notice to the knowledge of the learned judge, because we were represented.
R3 was represented.
We were represented. ನಾವು ಅದರಲ್ಲಿ R3
What about this division bench judgment?
Swami,
Division bench judgment which has been referred to.
other division bench not pertaining to this notification, which stated that Karnataka Act is repealed. So the learned judge took
It
that.
did not deal with this.
Not
one.
in this.
That is in
ಈ
respect of
notification
BDA.
ಹೋಯ್ತು
BDA.
ಈ particular petitioners ಗೆ, there the learned judge took this thing of the division bench, which said Karnataka Act is repealed. I will produce this division bench judgment also. My learned friend,
Do you have a copy of it?
I will produce. ಹುಡುಕಿ ಕೊಡಿ.
That's in respect of BDA.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಅದು ಕಾಪಿ ಅದು 3539 to
ಹಿಂದೆ ಒಂದ್ಸಲ
3542
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರು. Next submission.
ಒಂದು ನಿಮಿಷ, let us see if it is pertaining to this or something else.
ಅಲ್ಲ ಇದು BDA.
ನೋಡ್ಬಿಡೋಣ, ನಿಮ್ಮಿಬ್ರಿಗೂ ಎಲ್ಲ ಗೊತ್ತೇ ನಮ್ಗೆ.
ಇಲ್ಲ ತಮಗೆ
3539
ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆ. ಬಿಡ್ಕೊಡಿ. ಇದು ನನಗೆ ತೋರಿಸಿ.
So it has no relation to this.
Yes. Owner Allah.
Yes.
May I request, last submission. My statement of objections, page 5, para 13, may kindly be.
Yes.
4 acre 13 guntas has in survey number 450 utilized under the layout plan in this manner. And in order to say that, my lords may kindly now see in page 21 onwards, R62, 21 to 47 are documents relating to possession certificate, allotment of land to various persons to establish and indicate as well to demonstrate that the scheme is completed. Because this has a relation to the first prayer that he has made, saying that it's a small portion, it's an area for park. So the municipality will have to answer whether the park is completely done or not, even otherwise.
That's part of your plan.
Part of our plan. Therefore, he will not have anything to say. Next is, my lord asked me, it went on for about 3-4 hearings regarding the payment of compensation because they denied. Kindly seeing page 10 of my objection, R2, which I had already brought to my lord's notice, but this is to emphasize the point that 2 payments were made. Bulk payment of about 50 lakhs were made by the commissioner, but per se to the land acquisition officer. And the 4th column, that is 6493, relates to the petitioner and family. We had also been able to buttress this contention by producing supporting documents relating to 1,49,100, which my lord saw the other day, wherein there was a civil case attachment, the decree holder took this money, and there was also a letter, all that is there. So he did not, there is a complete concealment of this fact.
Yes.
So a person who comes to this court, there is a complete concealment. This has taken about 10 years before he approached this court. Kindly see, this was made in 1993. 16 to 93 is my deposit.
The fourth,
My lord?
this is your fourth argument.
Yes, ma'am. Last submission.
Title four.
Last submission. 6493 is the date when we deposited. And he approached this court in 2017 without even explaining the delay. And much less he did not explain that he has already received. So therefore he didn't come to this court with clean hands.
Yes.
The last one, which we are not able to establish, we are able to establish only through this, because my lord said directed the assistant commissioner to produce certain record indicating payment. They have produced one, that is 1,49,000. They have not been able to produce this 65,852. Though we have been able to produce the public records indicating that this payment is made. There are seals of the state, the civil court, as well as by the Urban Development Authority, which acknowledgement by the Assistant Commissioner's Office. But we don't have the overlay for the check, that's a photocopy of the check to indicate that payment is made.
Yes.
This is, it was made in 1993. Lords can take judicial notice. We are dealing after so many years. It is their duty to produce, but they are not done it. There might have been a slip. But the fact remains that he did not make a mention of 1.5 lakhs was deposited long back. That was not the contention. That is not the contention in which he has approached this court. Nevertheless, this was one of the points that was raised during the pendency of the proceedings. Therefore, I beg to submit that the money is also paid. He didn't deposit. He didn't say anything about this. So he didn't come to court with clean hands. His lands have already been, possession is taken, park, everything, roads, sites have been given. And the fact that he did not disclose this and public records, there is a presumption under the provisions of the Evidence Act indicating that it's there. Merely because the Assistant Commissioner is not able to produce this record of 70,000, nothing could be stalled at this point in time. And it should be dismissed with exemplary cause because he did not accept this. Despite we producing this before this honorable court, he kept on saying that he has not received. That's all. Great. Yes. 24-2 lapse ಅಂತ ಹೇಳಿ 24-2 lapse ಆಗಲ್ಲ because of all this. His prayer
Been taken or
yes,
deposit has been made.
his prayer is 24-2. Second prayer is 24-2.
Yes.
Insofar as prayer is concerned, my lord, I filed application to amend the prayer and also ground kept pending deciding along with the main matter. My lord, insofar as acquisition proceedings, my lord, the notification has been issued in hold act. There is no doubt. My lord, even if,
Also under the old act.
my lord, even if,
Fully under the old act.
my lord, even if passed on under both act, my lord, law says the Kuda Act come, my lord, in the year 1987. Kuda Act leads the field, including Chikmagalur urban development. For a moment, my lord, kindly take the Kuda Act, my lord, wherein it specifically states the act came in the force since from 1st May 19.
But you are too late in the day to question the
My lord, insofar as
acquisition. You can only go under 24-2.
acquisition is concerned, my lord, the denotification proposal sent to government is pending. The rejection of denotification has not came to my knowledge.
So that is something which we cannot consider in this matter.
My lord,
We are agreed by them not considering your denotification representation. It is a different issue.
my lord, till,
After
my lord,
30
till I
years,
filing the writ petition,
I think.
my lord, till I,
Yes. What do you want us to see in Kuda?
my lord, Kuda Act, my lord, came act into force since from 1st May 1988, my lord,
Yes.
including, my lord, Chikmagalur Urban Development Authority. When once the, my lord, Kuda Act came into force, the acquisition should be in the Kuda Act.
Yes.
My lord, the authority cannot go for old act or central act.
Yes.
That should be seized. My lord, my lord, that's my first point. Insofar as, my lord, after acquisition, my lord, award has been passed. My lord, my request of denotification has been accepted.
Don't re-argue the matter. We
Lord.
are in reply.
My lord, they passed, my lord, a resolution, say on 2 occasions, same.
Again, we are repeating. Don't
My lord.
re-argue.
Please, my
reply.
lord, insofar as, my lord, compensation is concerned, my lord, compensation has been not paid. My lord, compensation had been deposited in treasury.
Mr. Lingaraju, now we'll have to put our foot down. Don't re-argue. You want a reply. Everybody is waiting.
Please,
We
my lord,
have argued nearly 3 hours in this matter.
insofar as 16-2 is concerned, my lord, there is no 16-2. 16-2 has been not passed, possession has been not taken. My lord, when it comes to the 16-2, my lord, the acquisition is going to be lapsed.
Since you are repeating everything, we'll close it. Reply arguments of
My lord, kindly consider my written argument, my lord.
Shankar. Written submissions filed by the petitioner is taken on record. Reserved.
Offshore holding. Offshore holding. Offshore holding.
ನೀವೇನ ಜಜ್ಮೆಂಟ್ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. ಆಫ್ಶೋರ್ ಅಂತ ಅಲ್ಲಿ
Sir,
ಐಪ್ಯಾಡ್ ಇಟ್ಕೊಂಡು ತೋರಿಸೋದು.
my lords are aware.
If it is not there on record, we are not looking at it.
Regarding section 19, 17 and 19 pari materia with 4 and 6. I'll produce that.
We are not looking at it if it is not there in record.
Great.
Otherwise, we could look at so many judgments then.
Survey copy to the other side.
Yes.
Serial number 7 adjourned. Serial number 8, Sunil Kumar Patel.
That's the case, my lords. Private land of the petitioners came to be notified as work property by way of a revised corrigendum, my lords. And your lordship has directed the ADLR.
This
conducts
survey, this
survey,
is
my
that,
lords.
yes.
Survey report is placed on record.
All of
And
you have received
says
it?
there is no, in the entire land, my lords, they have done the burials.
All of you have received the survey report?
Yes, yes, my lords, I have received.
Ready to address arguments? Ready, madam?
Yes, madam.
Ready.
Yes. But I've filed the convenience compilation, my lords, which contains all the pleadings and the memo.
When did you file it?
It was filed on 17/8 minutes. Yesterday, it
17/8.
seems. my lords.
Yes.
Yes. There's 3 bits of lands, my lords.
Survey report to Kodi.
Survey number 56/1A, measuring 1 acre 12 guntas, and other 2 bits of land were purchased by one Chicklingappa and Narsimappa, my lords. That sale deed is produced by annexure A, and typed copy is also placed at page 24 of the convenience compilation, my lords. Whereas this was purchased in the year of 1981, my lords. Thereafter, all the 3 bits of land which were purchased came to be converted in the year of 1983, my lords. Conversion is also, order is also placed at annexure B, my lords. Thereafter, upon the conversion, my lords, your lordship may kindly see the conversion order. Lordship would find it annexure B, ink page 27 of the convenience compilation. Here, your lordships can see the 3 survey numbers measuring 2 acre 38 guntas in survey number 55/21, 56/2, and 56/1A of Jarak Bande Kaval village. This,
You have multiple numbers in this. Which number do we look at?
my lords, the page number which is in the circle, my lords.
Why do you give multiple numbers to confuse?
Sorry,
the
my lords,
people?
when we do the convenience compilation, we.
So you should whiten the other thing.
Sorry, my lords, that.
Now it is in the circle.
Circle, my lords.
Page number?
27, please.
Yes.
Yes. The conversion order, my lords. This is dated 26/6/1983, my lords. In this conversion order, my lords, 3 lands which were purchased by annexure A came to be converted.
2 acres, 38 guntas.
38 guntas in survey number 55/21, 56/2, and 56/1A, my lords.
We are concerned with 56
56/1A now, my lords. Because this
or 1A?
1A, my lords. 56/1A is the land which has been notified as work property.
Which measures 1 acre, 12 guntas.
12 guntas, please.
Now, how do we see what is the extent converted?
The conversion was done to the entire bit of land which were purchased under annexure A, my lords.
2 acre 38 guntas.
What is purchased is available in ink page 25, my lords. The typed copy of the sale deed. That 1 acre 12 guntas. That is pertaining to survey number 56/1A, my lords.
Yes, 2 acre 19 plus 9, 238. Yes.
Please. Well, subsequent to conversion order, my lords, a layout was formed. And the layout plan, your lordship would find at annexure D, page 34, my lords.
Sanctioned by whom?
This is sanctioned by
Nobody.
Jarak Bande Kaval Panchayat, it seems, my lords.
Illide.
ನಕ್ಷೆ ಮಂಜೂರು ಮಾಡಿರುತ್ತೆ ಅಂತ ಹೇಳಿ 12/10/1992 there is a round seal, my lords.
ಏನು
ಕಾಣಿಸ್ತಾ ಇಲ್ಲ, but anyways, date is forthcoming is 12/10/1992.
Yes.
Yes, ma'am. Thereafter, my lords, various sites were formed and the sites were sold to prospective purchasers. And thereafter, strangely, in the year of 2010, my lords, a corrigendum came to be passed, uh, adding survey number 56 as
Page.
page, my lords. Corrigendum. Corrigendum.
ಬೇಗ ಹೇಳ್ಬೇಕು.
Yes. 84. Page number 84, please, my lords. '84, '85. This is a corrigendum came to be issued on 23/10/2010. This is not notified, my lords. Anyways, I'm referring here for the first time. In place of survey number 55, 3 survey numbers came to be inserted. Lordship can see the overleaf, yes, page 85.
It is not gazetted.
Not gazetted, my lords. The first time they insert survey number 56 there in the corrigendum. Subsequently, by way of revised corrigendum at page page 48, please, my lords. Revised corrigendum.
Page 48.
Page 48 minutes. Annexure H1. This is 9th July 2010, my lords.
Yes.
They insert survey number 56/1A. 56, 1 acre 25 guntas. Corrected entries 56/1A and 56/1B is inserted.
48 is a gazette notification.
Yes, my lords. This is issued on the basis of corrigendum, which is not gazetted.
You just said corrigendum is not gazetted.
Yes, my lord. This is 23/10/2010. Corrigendum is not gazetted. The
Revised
revised corrigendum is gazetted, my lord. That is, this revised corrigendum is based on the corrigendum which they had issued.
What is the difference in this and that?
Lords, first, my lords, the survey number 56/1A was never here what they in the revised corrigendum, they say 56/1A and 56/1B. Put together, they say 1 acre 25 guntas. I'm only concerned with 56/1A, which is 1 acre 12 guntas. This I have challenged, my lords.
Yes.
Yes, my lords. While adding my property as a work property, notifying as a work property, they have not followed the procedure as contemplated in law, my lords. That is, the coordinate bench of this honorable court has passed an order in WP. Citation is also placed, my lords.
When did you file it?
This is filed on 29/7/26. My lords, copies are also served.
ಇಲ್ಲಿದೆಯಾ ಇದೆಲ್ಲ ಒಂದೇನಾ
ಇದು ಕಟ್ ಮಾಡಿಕೊಡಿ ಇದು.
ಎರಡು ಸೆಟ್ ಇದೆ ಕಟ್ ಮಾಡ್ಬಿಡಿ.
existence of 259 ಇದೆ.
Pretty.
55 bar 1 existence of
Page.
259.
In fact, revenue authorities have given an endorsement saying that there is no land available in survey number 56/1, my lord. That document is also placed on record, my lords, at page 259, my lords, in the convenience compilation. 55/1.
You want to refer to? You want to refer to citation or you want to refer to any other?
Yes, yes, my lord. Citation, my lords.
Yeah, citation you want?
My lords, in fact, page number 151 for the fourth citation, my lords.
Yes. Paragraph.
Lords.
Mr. Counsel, you have to be fast. You can't be sitting here and standing
Sorry,
here
my lords,
and
I was
reading.
led by senior counsel D.R. Ravishankar.
But you
my
are
lords.
arguing.
Yes, my lords. He's
You
held
not
up
ask
in.
for passo or anything. So if you're arguing, you have to be ready.
Yes, yes, my lord. That's why.
People who are waiting.
Yes. Let's pay para 34 onwards, my lords. Sorry, 33.
Yes.
Thus, the law contends that after the preliminary survey is conducted, the list of works is required to be published in the Gazette. And this list is required to contain the details of the properties of the works. This is obviously to declare and notify the works that existed in the state and also to notify the properties which the work owned and possessed. Section 6 of the Act provides that for raising the dispute regarding the works, if any question arises as to whether particular property specified in work property in the list of works published under Section 5(2) of the Act is a work property or not, or whether the work is specified as Shia works or Sunni works, this dispute could be raised by the board or mutawalli of the works or any person interested therein by instituting a suit in the civil court. A limitation of 1 year to institute the suit was also stipulated in the said provision. Here in the case at hand, my lords, this survey number 56/1A, which I am the lawful owner, was never notified as a work. Initially, the survey number 55/1, in place of which my property was brought in, that is not at all in existence, my lord.
Yes.
And further, my lords, thus the question as to whether the property specified as a works property in the list of works or was not a work property was to be determined in a suit instituted for that purpose, either by the board or by any other person interested. If no suit was instituted as provided under Section 6 of the Act, it is obvious that the list of works published under 5(2) of the Act became final, and as a consequence, the property mentioned therein would have to be considered as work property absolutely. In this case, it is not in dispute that the house property that is pertaining to that case, my lords. Here also, my lords, our property was never notified as work property. First, they brought in by way of corrigendum, my lords. Thereafter, yes, my lord. First, they brought in by way of corrigendum, which was not gazetted, my lord. Thereafter, they publish a revised corrigendum that they gazette, my lords. Hence, my lords, my private property came to be notified as work property without following the due process of law. And now, on top of that, my lords, since 2013, my lords, this pendency of this petition, though there's a status quo order passed by this honorable court, insofar the possession is concerned, my lords, they continue to bury the dead bodies, my lords. Now that as your lordship has ordered for the survey of the entire land, now it is quite clear, that, my lords, that entire land has been, in the entire land, burials are there, my lords. So my entire land has been utilized by the work for the purpose of, they have converted into graveyard, my lords.
So what is to be done?
I was told, my lords, there is one more property which is work property that is left vacant as it is, my lords. That is measuring to an extent of 2 acres. In survey number 58 is what I was instructed, my lords. So that can be compensated, my lords. That would serve the.
You amended your petition for that. Is that a relief that you have sought for?
My lords. There was an amendment sought also, my lords. We have sought amendment To prayer D, my lords, at page 16, my lords.
You are asking for removal.
Removal we have sought.
Alternate allotment have you asked for?
Alternate allotment is not sought, my lords.
Orally ಹೆಂಗಪ್ಪ ಹೇಳ್ತೀರಾ?
Then I shall have to seek for an amendment, my lords.
Is anything else?
That's it now.
Yes, madam.
Lord, my primary contention is that the prayer in the writ petition is to question the both the corrigendum and the revised corrigendum issued, which is gazetted. That is there is an alternative remedy to question that in the, and the division bench decision, I mean, division bench has taken the view that even a corrigendum or a revised corrigendum also stands at the same par as a notification. So the remedy is to question it before the, I will give that decision. But before that, my lord, kindly see the original, I mean, rather the xerox of the sale deed that is relied upon. In this, my lord, sale deed, there is no survey number 56/1A at all. Therefore, the petitioner does not have any rights.
Annexure A.
Yes, Annexure A, kindly see the handwritten sale deed. The sale deed is number 15699 of 1980-81. That is what the typed copy is shown to my lords.
Yes.
I would say, first of all, incorrect submissions are made. It is suppressed. In this handwritten sale deed, 56/1A doesn't feature at all.
In the typed copy, it is mentioned.
Yes, that is the mischief that has happened here. I mean, if I can say so. And they are asserting that.
This is a very serious.
Yes, no, it is a serious. It's very serious. Kindly see in
You have
this.
to make good that submission.
No, kindly see in this entire, I just went through
Let
this.
us read it. If
Yes,
it is so,
Lord.
then it's a very serious issue.
Lord, all this, Lord, is a bit difficult to read. We can go to the next page. Your Lordship will take page number, this is not marked. 14, my lords would get? No, 18,
Convenience
19,
compilation
20,
22,
20,
my lords.
21. Page number 21 in the convenience
The
set.
number ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಅದ್ ಕೊಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
22, please, my lords.
ಅವ್ರ ನಂಬರ್ ಆಗಿಲ್ದೇ ಇರೋದು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, it's a short matter only for, my only is preliminary
ಎಷ್ಟು
submission.
ಪೇಜ್ ನಂಬರ್ ಮಾಡಿಲ್ವಾ? 10,000.
ಇಲ್ಲ ಬೇಡ. No, it happens.
You have
It's
to
quite a.
be this one to the council. You have
Sorry,
to
my
use,
lord.
No, because I
was
have
not
been
aware.
repeatedly saying, Lord, from the time from 2013, it has been my only contention that you do not never purchase 56/1A every time the matter was heard. And I have pointed this out. And yet they want to assert only from the typed copy that they have purchased.
Okay, let's
In
read
2016, they file a rectification.
let us read this document
yes,
and
yes.
close it.
Lord, this,
If it is so, it is so.
Lord, 22 would be the page. As per my-
From measuring zones to north of current. Own choice and where the schedule.
Own choice
property is
where the
not
scheduled property is not
in
land
Inamti
confirmed.
land. Inamti
Land
land
comes
confirmed.
under the typed copy.
Inamti land confirmed land or comes under the Darkas. It does not contravene to the KLR or KL grant routes and is away from Gramtana limits. The present market scheduled property
The
is
present market value of the scheduled property is 19,000 only. ಆಮೇಲೆ schedule of the properties ಅನ್ನಲ್ಲಿ
survey
land bearing
55
survey number 55/1
A.
1A situated at Jarke Bande Kaval, Yelahanka Hobli, Bangalore, North Taluk, measuring 1 acre 12 guntas. Bounded as east by so and so, so and so. Next to land bandu, land measure bearing 55/21 and situated at so and so. Next land bandu 56/2.
21.
Idu Moore land they have purchased in this sale deed. So they never purchased 56/1A. Now their contention is in 2016, finally a rectification was given by the concerned authorities.
The sale deed was rectified.
This rated Allah, one endorsement was given. That's what they have produced, stating that this has to be read as on how, Lord, a rectification of a sale deed has a process under the
Where is that
Registration Act.
rectification?
That
That's page
rectification endorsement
143,
they have
my lords.
produced.
We did not ask you, we'll come to you.
Sorry.
You have a lot to answer.
So my humble submission is that
Where that
yes, yes, a bit this one. So your lordship may have to bear
We'll
with
ask
me a
you now,
bit.
where the rectification in the convenience set?
That's
One
page
40.
143.
143.
ಹ. ಇದು 2016 ಅಲ್ಲಿ ಆಗುತ್ತೆ. ಮೇಲ್ಕಂಡ ವಿಚಾರ ವಿಮರ್ಶೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 4/2/1981 ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ನಂಬರಾಜಿ ಸೋ ಅಂಡ್ ಸೋ ಸಪ್ಲಿಮೆಂಟರಿ ಡೀಡ್ ತಿಳುವಳಿಕೆ ತಿದ್ದುಪಡಿ ಮಾಡಿ ಸದರಿ ಲೋಕಪಗಳನ್ನು ಸರಿಪಡಿಸಿ ಹೇಳಿ ದಸ್ತಾವೇಜು ವಿವರಣೆ ಸೂಚನೆಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 56/1A ಎಂದು ದಾಖಲಿಸಲು ನೋಂದಣಿ ಕಾಯ್ದೆ 1908 ಕಲಂ 68(2) ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರ. By this time in 2016, a corrigendum revised was issued and gazetted.
This is a supplementary deed.
Yes.
They have got a supplementary deed subsequently. So by the time they got that change, there was already a notification gazetted.
Who did you purchase this property from?
But he purchased it from some one Muslim family, which family dedicated this entire estate for Eidgah, for Qabristan, and there is a masjid. And some survey numbers were a bit confusing, and so there were a lot of corrections that was made, and some portion were developed by the army, these employees association, and it went all the way to Supreme Court, and then another survey had to do. Because of all this, we got the corrigendum issued. And in the corrigendum was subsequent to a public notice. There was a public notice issued. There was a hearing called for. I have produced that in my statement of objections. So therefore, my lord, we have the power to do so. We have followed the natural justice. They themselves did not have the right over 56/1A on the day it was said. Even otherwise, these are all disputed questions of fact. If they want, they should file a proper suit. And now the report of the report which came, Lord, your lordship would take that. Can we pass on? I'm just passing on the colored version.
Yes.
Lord, I read this. One Yelahanka Taluku, Yelahanka Hobli, so and so grammar, the Kannada, whatever they have given a summary. 55/1, 2, 3, all these numbers, mattu 57 ralli, Manya Ghana Ucha Nyayalayada writ arji, so and so. That's what I said, my lord, that this was pending before this court. Now the correct one is 2. Registration number 55/1, Bhagashaha, so and so. Then 56/1 ರಲ್ಲಿ ಭಾಗಶಃ 2, 3, 4, 11, 16 ರಲ್ಲಿ ಹಾಲಿ ವಾಸ್ತವಂತೆ ನಿವೇಶನಗಳಾಗಿ ಅಭಿವೃದ್ಧಿ ಹೊಂದಿರುವ ಪ್ರದೇಶವಾಗಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 55/1 ಭಾಗಶಃ ವಾಸ್ತವದಂತೆ ಖುಲ್ಲಾ ಇರುವ ಪ್ರದೇಶವಾಗಿದ್ದು 56/1 ರಲ್ಲಿ ಭಾಗಶಃ ಮತ್ತು 57 ರಲ್ಲಿ ಪೂರ ಜಮೀನಿನಲ್ಲಿ ಸಮಾಧಿ ಕಲ್ಲುಗಳು ಸ್ಮಶಾನ ಕಬ್ರಸ್ತಾನ್ ಇರುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. Then next matter 4, I would request your lordship's attention. 56/1 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ 26 ಗುಂಟೆ. ಆಕಾರ ಬಂದಿನಂತೆ ದಾಖಲಾಗಿದ್ದು ಈ ಪೈಕಿ RTC ಯಂತೆ ದಾಖಲಾಗಿರುವ ಸರ್ವೆ ನಂಬರ್ 56/1A ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 12 ಗುಂಟೆ ಪೂರಾ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 56/1B ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ 14 ಗುಂಟೆ ಪೈಕಿ ವಿಸ್ತೀರ್ಣ 0.14 ಗುಂಟೆ ಜಮೀನು ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 1.26. So that's why we issued that corrigendum, revised, because 56 became 56/1 and 56/1A and 1B. And 1 acre 25 guntas totally was portion of 56/1A in 1 acre 12 guntas. 14 guntas came in B. Therefore, we had to issue that revised corrigendum to include both. ಹಾಲಿ ಪ್ರಸ್ತಾವನೆಯಂತೆ ಜಮೀನಿನಲ್ಲಿ ಸಮಾಧಿ ಕಲ್ಲುಗಳು ಸ್ಮಶಾನ ಕಬ್ರಸ್ತಾನ್ ಇರುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. 56/1 ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. Then note 59. Now my submission is in the entire extent of 56/1A and 1B, which we have notified as 1 acre 25 guntas, which does not find a place in his original sale deed, the actual sale deed, is full of graveyards. It was dedicated as a graveyard, and from time immemorial they are burying graves, and they are still continuing to bury graves. And there are old graves that was not part of my lord's order, so they have not written. But it is not that in the past 5 years we went and buried everyone there. That's the kind of submission. So possession we have been from past 1964 onwards. They don't have a proper document for having purchased this. It was pursuant to a corrigendum, to a correction. In these kind of disputed questions of fact, and also whether they are really in possession or not, which now the survey says they are not in, and there are graves there. My thought was, my lord, at least if substantial portion was not with grave, I could consider to see if you have not used. And some areas now, as it become habitated, we are stopping graves. So if it is not used and they are also making some sites and neighboring, maybe we could try to do something. But my lord, after getting this reply, my humble submission is, it is a pure case of disputed facts which requires a full-fledged trial. I'm going to rely on 2-3 decisions to say. And after this, my lord, one more fact. In 2019, the Act provides for second and subsequent surveys. As I said, there are 3 or 4 survey numbers: 55/1 up to 21, 56/1AB. I'm talking about our properties. Then 57 and survey number 6. All this is a cluster in this Yelahanka area, out of which 6 went into dispute, and it went all the way to Supreme Court. Supreme Court said you make a survey, and when we did all these surveys, this is how it came about, and that's why we issued corrigendum various. After that, exercising powers under the amended provision of section 5, 4, 5 and 6, the state government conducted a subsequent survey, second survey, and they after that issued a new notification and correcting all these entries, and 56/1A has been given. This was done in 2019. Therefore, my lord, a state machinery, this is not issued by the board, that was issued by the state government. So there is a state notification, 3 notifications are there, 65 notification is there. So these are all disputed facts. My humble request is, it's not a case that can go within for district jurisdiction. I'll rely on couple of decisions. Michael, our copy. One copy of it. Same as this. Please. But we filed it, but we'll give one more. This was filed in 2025 itself, 28, 22. Although it was heard before another judge, and then the judge felt it was, he had a conflict of interest. So that's how it's come before. That's all. But I'll just run through the decisions. I'm not.
Yes.
Lord, this is the first decision. Lord, is a a civil appeal. It is a reported decision. We will not be given the actual. The court traces the entire history of 83 and dispute related para 9 onwards, my lord. 10, in our opinion, all matters pertaining to Waqf should be filed in the first instance before the tribunal constituted 83 of the Act and should not be entertained by the civil court or by High Court straight away under Article 226 of the Constitution. It may be mentioned that the Waqf Act, so and so recent parliamentary statute, Lord, it culls out all 83, 84, and my lord, thus the Waqf Tribunal can decide all disputes, questions, or other matters relating to Waqf or Waqf property. The word any dispute, question, or other matter relating to Waqf property are, in our opinion, words of very wide connotation. Any dispute, question, my lord, that's how the court has gone through. And there is a specific section, section 4 and 5, that is not called out here. I will show it in a minute. And last para 25, my lord. We hold that only the Waqf Tribunal has jurisdiction in matters and the parties can approach the Waqf Tribunal if so advised, so the paper stands allowed. Then, my lord, this is this next petition was a single judge's order, but this has gone in division bench and confirmed. That also I have produced. Para 4, page 19. No, this is writ petition number 5369.
Yes.
The learned counsel appearing for the board would, however, point out that it is that it is not as if the property was not notified in 65. It was indeed shown as dargah, but without proper boundaries being indicated. It is this which has been supplied by the corrigendum. There is no attempt to play mischief as sought to be unfairly alleged by the learned counsel of the petitioner. In any event, this controversy could be addressed in a suit that the petitioners may choose to file. The question is left open and the petitioners having bona fide proceeded. Even the corrigendum also, I want to show, this was a case of a corrigendum and a notification 65. To clarify the notification 65, we brought corrigendums. Court said notification and corrigendums both should go before the tribunal. This has stood confirmed by the division bench. I have produced order subject. Lord, this is, Lord, I just want to show this civil appeal number Punjab Waqf Board. I only want to show the prima facie of Lord, para 9 and 10 of this decision. Notwithstanding the fact that the defendant has not challenged the genuineness of the notification issued by publication in Gazette declared the property as Waqf. The first appellate court, after referring some of the provisions of the Waqf, came to the conclusion that mere production of Gazette notification Exhibit P2, the plaintiff cannot succeed to establish the property. Lord, para 14, I'll go straight away, my lord. Admittedly, no one has challenged the genuineness of the notification whereby the suit property was declared as Waqf at any stage of the proceedings. In the absence of such challenge, the court shall have to draw a presumption with regard to the genuineness of the notification, but no allegation with regard to genuineness in this case. Lord, the next decision also is more or less the same. I will not trouble my lords. Lord, why I have filed is the entire history of the act has been taken into consideration. All provisions, how the act is structured. That's what his lordships have. In this, I only want to point out page 58. I said that I will rely on 4, 5, and 6. That is what I wanted to point.
58.
Page 58. I wish that they have not culled out 4. 4 and 5 are the better sections. Your lordships are aware, have seen it, have shown it many times. 4 is where there is a government officer, deputy commissioner notified as a survey officer, and he conducts a survey under 4, and a report is put which is vetted, and then a list is sent. Then the government vets that list. Thereafter, it is notified under 5.2.
That is the initial 1968.
Even in
55.
It happened. Even this also, my lord, public notice was issued as was done at that point. I have read. Lord, this is, if any question arises whether a particular property, specified Waqf property in the list of Waqf is a Waqf property or not, whether any specified. So this is 6. It says the board or mutawalli or so and so may institute a suit in the tribunal for the decision of the question, and the decision of the tribunal in respect of such matter shall be final. Lord, I straight away show in my statement of objections the public notice that I have produced. Lord, I'll finish this and your lordship could see that. to show that opportunity was, but even otherwise, at that point of time, they never had any right over 56/1A with utmost respect. So it was not that we could have to give them any specific note. Then, Lord, after taking all the earlier cases also, this decision, the court said that the tribunal is the most appropriate forum for deciding. One more
Yes.
That writ appeal I want to show.
Public notice issue ಮಾಡಿದಾರ public notice the 65 notification.
Yes.
This I just want to show that the word corrigendum also is used.
There's no corrigendum word.
But it is also is there.
Addendum. Para two.
Addendum and corrigendum, all addendums and corrigendum part form. That's what I
We
wanted to
added
just.
by addendum dated 26th
Please.
September.
So
Para
this
two.
was a case where there was a corrigendum and an addendum thereafter. So therefore, my lord, even in such cases also court has said that the alternative remedy is most efficacious. This is what I wanted to show in this. Lord, my lordship will kindly see my statement of objections.
It's part of the convenience set.
Yes, my lord.
Para?
Page number ಕೊಡ್ಬೇಕು sir? R1.
Page, sorry.
Lord, it is 75. Your
75 my lord.
75.
55 para.
Lord, 75, I have stated. Para 3, my lord, I've stated. 8/2/2010, WACFAX are requested for the board to issue corrigendum for rectification of the extent of. Thereafter, not on the basis of a letter and mahazar, board issued corrigendum. So and so, I have produced the public notice and the mahazar.
Yes.
A spot mahazar was conducted. That your lordship will get at page 81 is the public, your lordship will see there. In the typed copy, I will show that public notice was issued. On 29 January 2010, 11:32, I fixed the public notice of this on the notice board of the Jamia Masjid, so and so, and the burial ground belonging to Jamia. So on the burial ground, this notice was put. And thereafter, this corrigendum came to be issued. Lord, in the difference between the corrigendum and the revised one is what your lordship will see in the actual.
So this one was also 57, 56 and survey number 6.
6, howdu.
Not
All
56.
three ge we had to.
1A, 1B illa idralli.
Ada ಆಗ್ಲಿಲ್ಲ ಅದು ಅವಾಗ. Thereafter, we got another report that it divided on 1A and 1B, and few months later, we have included that, but extent is not changed. 1 acre 25 guntas continues.
Yes.
So the second corrigendum, a revised one was issued to make it into 56/1A and 1B. And thereafter, the final second survey notification issued by the government, that is at page 2019, that came to be issued.
Page.
Please, Lord, we'll give that. The page number could be 2019.
67. 67.
67, no.
67.
No, no, 67. No? Yes, my lord. 2019. But as I said, 55 and 6 belong to the neighboring area. For that, they issued separate. For 56, the government, but this is what is issued in excess of so and so. Amended during 2013, the government of Karnataka Minority Welfare Department, further receiving from the Deputy Commissioner. So letter dated so and so. It is verified and approved by the administrator. So and so, the government of Karnataka is hereby notifying the following immovable properties as work. And that is at serial number 2 of this notification, 56/1A and 56/1B with Chakkubandi. Chakkubandi was again absent all along. But as lands develop, my lord, we probably get a better picture of what really is there, and that's how.
Yes.
So therefore, my humble submission is that this petition involves a huge disputed questions of facts, and it all requires evidence. The latest report also says that they're not in possession of the property. There's no prayer for possession even if they succeed. So there is to be a comprehensive suit. They have the time, they can, and therefore writ petition by itself is not maintainable. Only one last submission, if you allow. 2013 petition with no malice or anything. Just I want to state as a matter of fact, 2013 it was filed. It was never taken up for almost 8 years. It was just, kindly see the order sheet. It was just been there in dormant. No interim order, nothing. So the delay, if any, cannot be attributed either to the respondent nor the court.
Or to the court.
Not to the court, of course, not to the court. There's no attempt made even to bring it up before the court. Not with responsibility, I'm saying I've seen the order sheets. Then from day one, whenever this was brought, we have taken a contention about the maintainability of the writ petition. Our objections are only towards that. Sum up, jurisdiction we have. Under the General Clauses Act, there's a power to give corrigendums. Provided it is same procedure you have to follow as it was. Public notice is issued. Subsequent surveys have happened. Supreme Court also ordered certain surveys. So taking all that into consideration, it was not that we took somebody else's property and made. As the survey numbers changed at the revenue level, the amendments took over here. So the amendments are part of the notification. They are all amenable to alternative remedy, and the petition has to be dismissed. It's my humble submission.
Yes.
Insofar as the survey number 55/1A, what is mentioned in the sale deed, that is an error, my lords. That is why we got it rectified by way of an order of deputy
How is the
registrar.
rectification by an order?
Yes,
Where is
my
the
lords. That I'll
rectification
point out,
deed
my
among the parties?
Yes, my lord. That I'll point out, my lords. My vendor, my lords, that they sold it in the year of 1981.
The document executed by your vendors?
No, my lord. But the boundaries remain same, my lord. That is what it is appearing in the rectification deed. And moreover, my lords, my lords may kindly see page 167, my lords. 167, my lords. It's an endorsement issued by the Revenue Department, Tahsildar's office. In fact, there was no land available by survey number 55/1A. In fact, your lordship may kindly see this endorsement is dated 10/8/2015, issued by Tahsildar's office. ಈ ಬಗ್ಗೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಮಿಲೋಡ್ಸ್ ಈ ಬಗ್ಗೆ ಪರಿಶೀಲನೆಯಾಗಿ ತಾವು ಕೋರಿರುವ ಯಲಹಂಕ ಹೋಬಳಿ ಜೆಬಿಕಾವಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 55/1A ಜಮೀನು ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ನಮೂದಾಗಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. In fact, my lords, in the year of 1981, when the property was sold, lordship, for a moment, kindly take the survey report. All are adjacent lands, my lord, 3 bits of land which I purchased. 83 conversion order is there, my lords. There is no chance that, my lord, survey number 56/1A was not purchased by the petitioners. Is my response.
Not at all. You complete it.
Please.
So in reply now you can't tell him that
Yes,
he is going
I'm
to.
sorry, my lords. This is the document which we are relying on. Why survey number 56/1A? It was a typographical error committed in the.
Is there a document executed by your vendors?
Subsequently, DR has passed an order. That's what we were referring to.
What is the question that we asked you?
Rectification deed is.
Is there a document executed by your vendors?
No, not vendors, my lords. A supplementary
Order
deed
passed
came.
by
the district registrar, my lords, based on which a supplementary deed came to be,
By whom?
my lords, parties.
In the entering, they made
No,
a
Mr.
typographical
Ravishankar,
error.
he has argued, let him argue.
I'm only clarifying that there was a typographical error in the
He
writing.
has argued, let him argue.
Very well.
Whereas that, there was a typographical error, my lords, that was rectified, my lords, that is the order says.
Where that supplementary deed?
Please, my lords, page 143 onwards, my lords, we have produced the documents.
143.
Yes, my lords.
Where the supplementary deed?
Supplementary deed, your lordship would find at 149, my lords.
Who has executed this?
Lords, this is
There's a
it's a
declaration made by you.
declaration made by my lords. Lords, what has happened, why this order was passed, my lords?
State a party?
No.
State a-
State a party here, yes.
Who is appearing for the state in this matter?
That if,
Mr. Jaffer? You are appearing in this matter?
before he starts, can I just show? if
We'll
you're
have
not-
one small inquiry in this matter. Yes.
Please. Lords, there was a error in the mentioning of survey number in the book of records of the sub-registrar. That came to be rectified by the order passed by DR, my lords.
Yes.
Because in fact, my lords, if lordship may kindly see the conversion order, my lords. If I would not have purchased survey number 56/1A, my lords, all the three properties which were mentioned in the sale deed of 1981, which I purchased, converted into from the residential services, my lords, in the year of 1980. That is what the conversion order says, my lords.
Yes.
And in fact, boundaries are all, they are abutting each other, my lords. That is why I wanted to refer the survey report, my lords. Your lordship may kindly see the survey report. It is quite clear, my lords. Survey number 55/21, survey number 56/2. Next is survey number 56/1A, my lords. And in fact, survey number 55/1A was not at all available, is what the endorsement given by the Tahsildar's office, my lords. Since the lands are abutting to each other, that's why I purchased it in one sale deed. While mentioning it in the records of the sub-registrar, maybe an inadvertent error, that is instead of survey number 56/1A, it is mentioned as 55/1A, my
Have
lords.
the original sale deed with you?
Original sale deed, my lords, that I'll have to. That
original sale deed copy
I'll-
ಹಾಕಿರೋದು ಅದು.
the certified copy is what produced, my
Certified copy ಅಲ್ಲ, certified
certified copy ಹಾಕಿರೋದು.
Original sale deed ಇದ್ರೆ ಅದನ್ನ photocopy
Certified
ಮಾಡ್ಕೊಡ್ಬೋದು.
copy, but I stand corrected.
What is produced is certified
Typed
copy.
copy should be in conformity with what is there.
What has happened, my lords,
Can't-
without alleged.
Not correct.
Giving credence to what he is saying, that there's a mistake committed by sub-registrar.
What has happened, my lords? I came on NOC, my lords, when the original petition was filed. I am not alleging on anyone, my lords. Why there was a mistake in the typed copy is what I am explaining, my lords. What is filed in the original writ petition is what I have reproduced, my lords. I cannot undo it now, my lords. But the fact remains is, my lords, the property which was purchased by the petitioner's father was for survey number 56/1A and other two properties. And if lordship may kindly see the supplementary deed, which is
The declaration unilateral by you.
correct, my lords, but the boundaries won't change, my lords. Boundaries prevail, my lords, because the schedule which is given in the sale deed of 1981 is as same as the schedule which is mentioned in the very supplementary deed, my lords. That would not change the, but all if I have purchased some other property, my lords.
Anything else?
Well,
Don't keep repeating, that's all.
I'm
You can
sorry.
argue any point, but
Yes,
don't
yes.
keep repeating.
Insofar as the mistake in the survey number, my lords, that is what my answer is, my lords, because deputy registrar, district registrar's order is there, and he has passed an order, and based on which the supplementary deed came to be executed, my lords. Lords, insofar as the 65 notification, my lords, in which survey number 55/1 is notified. Survey number 55/1 is still very much available. They say that 56 was not there. There were proceedings where certain burials were taken place. That is why we issued a public notice, and we brought in these lands which were where it is a notified work property. It was left out. That is why we brought in by way of a corrigendum and subsequently revised corrigendum. My lords, in the 65 notification, my lords, survey number 55/1.
They have already started the arguments.
He has argued, madam has argued, this is reply. At reply
Because
stage, if
we
you
are
had
led
come
by-
in the initial stage, we would have not now. Let him finish.
Fair opportunity of, because I understand
That would not,
is-
that is not a fair statement to make.
Lordships, I'm only requesting if your lordships were to extend a fair opportunity.
That is
I
not-
assist your lordships. Ultimately, we are here to assist
Mr.
your
Ravi
lordships.
Shankar,
Otherwise, my lords, I wanted to, I just said that your lordship kindly excuse my presence is essentially.
that you
what I
can
said.
ask. He has been arguing for last 1 hour now.
True, my
I
lords,
was
but
on my election code on 16. I could
We
not
can't help
immediately
it.
rush back to the court.
We can go to the other court now also. He's arguing, don't do that. It'll be sending a very wrong message to everybody.
I understand.
Yes.
Lordships.
Survey number 55/1 was notified as Waqf property in the year of 1965, my lords. That is very much on record, my lords. Well, that is still available. That is what survey report also says, my lords. And in fact, my lords, recently they gave a representation to the revenue department to change the revenue entries, mutate the revenue entries in the name of Waqf board, my lord. That is also available, my lord. That is also placed. Survey number 55/1 is the Waqf property. Now, earlier, it is not the case of the Waqf board or the state which has notified my land as Waqf property, that my land was wrongly notified either in the original notification or it is in the possession of the Waqf board, my lord. It is never the case of the Waqf board or the state that in my property, the Waqf board was in possession of the same, my lord.
Yes.
In the year of 1965, my lords, survey number 55/1 is notified, that is very much available. On what basis my property was notified by way of corrigendum and subsequently by way of revised corrigendum is not forthcoming. If at all, if they have any right, it is for them to approach the tribunal, my lords, not me. Your lordship's order is there, my lord. It is them who have compelled me to approach.
Fortunately, you have come, what to do?
My lord, because
You should have kept
situation compelled me, my lords. In the year of 2010, my lord, they say, my lord, they issued a public notice and then thereafter they issued corrigendum and revised corrigendum followed all these
What do
things.
you have to say about all the graves in the property? Now the survey report is there that 56/1A.
But that, my lords,
and
I'll
B,
have
the
to-
graves are full, the property is full of the graves. You are not in possession.
My lords, in the year of 2013, when the petition was filed, there was an interim order passed by this honorable court maintaining state, directing the parties to maintain status quo insofar as the possession is concerned.
Which order is this?
My lords, page number 62
Hmm.
of the convenience compilation,
Yes.
69, sorry, my lords. This is a Google map, Google
What is
images.
that order? First show us the order. And what is the status quo which has been defined? In 2013, you say?
Yes, sir.
Status quo with what? Position, how many position?
ಏನಿಲ್ಲಪ್ಪ 2013
ಅದನ್ನೇ
ಅಲ್ಲಿ.
ಹೇಳಿ ನೀವು. ಹೇಳಿ. ಅದನ್ನೇ ಹೇಳಿ.
Yes,
Let's order dated 13th December 2013, my lords.
yes.
Parties shall maintain status quo with regard to possession, my lords. My lords, subsequently, as I mentioned, my lords,
How does that help you? They're in
Let's-
possession
Ought to.
by the
as on
graves
the
being
date,
there.
my lords, these are the Google maps which have placed before your lordship at page 64 onwards.
Today, the graves are there.
Today is there, my lords, when the order was passed, there was no, the not fully
Oh, no,
occupied,
no.
my lords, of
Wrong.
course, I can,
Wrong.
Yes.
of course,
Really.
as on the date of the order, my lords, status quo order which is passed, land was vacant, my lords. Recently, they put up the board saying that it land belongs to Jamia Masjid and all. We have filed complaints. Those documents are also placed on record.
Yes.
All these developments were, my lords, subsequent to me getting an order of status quo. Yet they continued the burials, my lords. Unfortunately, matter was not taken up for hearing, my lords. Maybe at the end of petitioners, they have not moved
Is
despite of,
anything else?
but insofar as the survey number, there is an error in survey number, what is mentioned in sale deed, my lords, that I have pointed out, my lords. In fact, there is no land available.
ಆಯ್ತಪ್ಪ ರಿಪೀಟ್ ಮಾಡಬೇಡಿ.
Yes, my lords.
Anything else you have, you say.
My respectful submission, my lords, there are three more judgments which I have relied upon, my lord, that contemplates the procedure to be adopted, my lords.
Which judgment are you relying on?
Yes, my lords. The state of Andhra Pradesh versus AP Waqf Board, my lords, 2022-20.
Paragraph?
So I'll mark it and give, sorry, my lords.
You mention it so that if they have anything, they'll make their
File,
submission.
I can reply
You
to that.
can't
I
give
know
it-
what to.
I'll mark it and give it without them knowing what you are giving.
Yes, yes.
Which is the para?
Mark ಮಾಡಿಲ್ವಾ? ಅದು ಹೇಳ್ದೆ.
This is a once a wakaf, always a wakaf.
One
Yes. ಆಯ್ತು, para number ಕೊಡಿ. ಅಷ್ಟೇನಾ?
Yes.
Sorry to, just to assistance only. Sorry, the page number, although RTC they have produced almost up to 2013 onwards. It is.
35.
2012 in the
Page 35,
page
annexure
35,
E1.
obliged lord. Lordship will see 2012, 13, all 55 only is being showing. ಅದು ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಯ್ತು ನಮ್ಗೆ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
55 is 55/21.
survey number.
There are 3 survey numbers.
37 is 56/1A.
Yes, that was in
21 and 56/2.
1213.
ಅಲ್ಲ 1A ಇಲ್ವೇ ಇಲ್ಲ, ಬರೀ 56, 56.
No, RTC at page 37 is
55,
For
Lord,
1A.
Lordship will say 55, 21 ಇಲ್ಲ. Just, Lord, what is there is there. I'm not trying to.
21 ಅಲ್ಲಮ್ಮ, 1A ತಾನೆ, we are concerned with
1A correct, ಅದಿಲ್ಲ ಅಂತ ನಾನು
Page 37 ಅಲ್ಲಿ ನಮ್ ಸೆಟ್ ಅಲ್ಲಿ ಇದೆ.
30, 56 ಅಷ್ಟೇ. 1A, yes. ಅದು ಒಂದೇ ವಾಟ್ ಮೈ ಲಾರ್ಡ್ ಸಾ. ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ 1A ಇಲ್ಲ.
ಎಲ್ಲದರಲ್ಲೂ
ಖಾಲಿ ಇದೆ.
38 ಅಲ್ಲೂ 1A ಇದೆ.
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ನೋಡಿ.
38 ಅಲ್ಲೂ ಇದೆ. ಹಿಸ್ಸಾ 1A.
ಹಿಸ್ಸಾ ಖಾಲಿ ಇದೆ. That's one.
ನಂಬರ್ ಸರಿ ಇಲ್ಲ, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
Maybe.
37 and 38 are 56.
Graves are there from 1957 onward. Lordship will see one such grave. To say from 2013 we are.
That is buried in the actual burial ground, which is there, it's survey number 57, sir. Just saying, survey number 57.
ರಿಪೋರ್ಟ್ ಇದೆಯಲ್ಲ.
Burials ಹಳೆ ತೋರಿಸ್ತಾರೆ, ಒಂದು ಹೇಳ್ಬೋದು, clarity ಕೊಡೋದಕ್ಕೆ.
95 ಒಂದಿದೆ.
57, 59.
Survey number 57 ಅಲ್ಲಿರೋದು, ಅದು actual burial ground ಅಷ್ಟು.
Report.
No, I wanted to. No, to say from 2000. Maybe survey time nalli I
Don't
should
even
have.
say 2013, they say last 5 years.
Oh, yeah.
In fact, my lords, Lordship, you can see the survey report. 56/1A is abutted by one more land, 57. That is burial. We do not dispute that fact, my lord. That is also reported. Now the clarity is to be given as to since when in survey number 56/1A.
Heard
Now that report is already placed, my lords, the
Sunil
entire land.
Kumar Patel, learned counsel for the petitioner, Ms. S.R. Anuradha, learned senior counsel for respond number 1, reserved.
Serial number 9. Yes, Rajshekar.
Matter, I was supposed to secure the records, my lord. The officers online, because they had some.
Maybe online, do you have the records?
No, I don't have the record. That's why I instructed them, because,
Why don't you have the records?
my lord, they could not get the records.
Why?
Because there was some.
Officer.
Records ಇಲ್ಲ, ಯಾಕಂದ್ರೆ oral instruction.
My lord, I have the records with me, my lord. My lord.
We have the record, my lord. In fact, on the advice of the Lokayukta and other thing, the briefing was,
What is the name of the officer?
she is Mangala.
My lord, there were 4 CDPOs in this, my lord. 4 CDPOs and the matter is from past 8 years. The petitioner has only challenged the follow-up letters. He's not challenged the main foundation letter.
We want to see the file.
I have it. I have the impleading application, the documents which my father had represented based on the joint directors midday meal scheme order, which the gas connections has to be transferred to the nearest gas agency based on the jurisdiction.
We can't go by what you are going. We want.
I
to see
have
the
it in
original-
the impleading application.
Mr. Dheeraj, we want to see what the original file is.
Okay.
And you can't have the original file.
Yeah.
As simple as that.
Yes.
And there are many more things there than what you have.
Yes.
And what is the name of the officer? Yes, Ms. Mangla. ACDPO Puttur. Ms. Mangala.
Ashwini, was the wrong word appa? ಮಂಗಲ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರಲ್ಲಿ
Entertainment at 4:45.
It lightens the atmosphere a little.
Yes, please, my lord.
Why is she not giving you the file?
But, there is the other, the deputy director, my lord. He was supposed to come with the file, my lord. Some meeting that he had to attend, so she could not come. But they said.
Somebody else could come. You only have to get the file.
I instructed them strictly, and I said, "You please come and answer to the court." That's why I said, "You."
When will you get the file?
No, because it is Puttur, they need 1 day to travel, my lord. It can't be tomorrow. It can be on Thursday, my lord.
Leave it
Thursday, my lord. Because
on
Friday,
Thursday.
Thursday.
Let
be on Monday
submit that the file has not been received since the who was to go for a meeting?
My lord, the deputy director, my lord.
Deputy director had to attend a meeting. Released on 20th at 2:30 p.m.
My lord, just one small submission, my lord. My lord, this is about the territorial jurisdiction of the gas agency, my lord. Whenever a new gas agency is allotted, they have a territorial jurisdiction. My lord, it is very similar to the High Court of the Karnataka, which has 3 benches of Dharwad. And my lord, matter pertaining to Dharwad bench cannot be filed in Bangalore bench. In the same way, my lord, it is based on the proximity.
What you say, you should tell many advocates. They should understand. They don't know about.
My lord, this CDPO is the expertise in the field, and she knows where her Anganwadi is located.
We have to
Based
see
on the
file, what is the
jurisdiction.
application of mine? What is the reasoning there? You are a party in person. That's why you would probably not know. We have to see it in a different way
Sure,
than
my
what
lord,
you
I
are looking at.
I understood.
That's
Released on 20th at 2:30.
could it be on 24th?
My lord, I request on 20th, my lord. I travel all the way from Mangalore, my lord, for this.
For
You are going
production
to
of
stay back?
document.
Sorry, my lord, I'm staying from already 1 week out here, my lord. 20th,
Not fair.
Aware of it.
travel all the way from
20th.
Upinangal.
Please.
20th. Interim order earlier than.
Serial number 10, Chandraprabha TS.
ಕೇಳಿಸಲ್ಲ ಅದು ಇದು ಮಾಡಿದಾರೆ ಇಲ್ಲಿ ಅಂತ ಇದೆ ಇಲ್ಲಿ.
That too at least.
Block.
Yes. For the petitioner, madam.
Yes.
Mr. Udayawalla will come. ಕೂತಿದ್ರಿಲ್ಲ ಟೋಟಲ್ ನಂಬರ್ 22 ನಲ್ಲಿ ಇದಾವೆ.
Where you last 2 times?
No, my lords, I was present on the last occasion. My lords had directed me to serve the copies of the report.
Now you have served the
It
report.
has been given to them.
Pass.
He will
13
come.
person ಇದಾರಪ್ಪ.
He was waiting. ಅಲ್ಲಿ ಮ್ಯಾಟ್ ರೀಚ್ ಆಯ್ತು ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ.
Yes, you make your submission, Mr. Kuber.
My lord, in the last occasion, the petitioner had filed some objections regarding the report. I received the full report of 23 pages. I also had filed a memo on 9/2/2026 and put in the annexures 13 to 26, out of which 15 to 26 are the objections to the report. I would like to file those now.
You're
Objection
filing-
to the report what I have received. I'll give it to you.
You have served a copy.
I will serve it right away, my lord.
You should have served it earlier. The petitioner party, what are you filing?
This is only the objection to the
Report.
report what they have given.
The respond number 4, party in person has filed objection to the inspection report. Copy thereof has been served on the counsel for the petitioner. Counsel for the petitioner is granted a week's time to go through the same and make his submission. Pre-list on 27th August. Interim order earlier granted is extended to next date.
Serial number 11.
My lords, I appear for petitioner. Writ of mandamus to consider my application, my lord, for enrollment, which is annexure D, my lord.
It's not been considered at all.
Please, my lord, till today not as considered.
Respondent was an employee in the year 1981 to 2017, and he pursued graduation in the year 2011.
Whatever you're telling us, put it in writing and give it to him.
We will consider the representation and
In how many days?
10 days.
Petitioner is before this court, Shri Ritesh D. Nayak, who has appeared for respond number 1, accepts notice for respond number 2 also. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the application submitted by the petitioner on 13/5/2025 at Annexure D has not been considered and the petitioner not enrolled as an advocate with the respondents. The counsel for respond number 1 submit that there are various reasons why it was not processed. Even if that were to be so, it was for respond number 1 to have put down the said reasons in writing and issued the said order to the petitioner so as to enable the petitioner to take the matter forward. Same not having been done, the petition, this court passes the following order. Writ petition allowed. A mandamus is issued directing the response to consider the petitioner's application dated 13/5/25 at Annexure D and pass necessary orders within 15 days from the date of receipt of a copy of this order. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be considered by the respondent in accordance with law.
Grateful, my lord.
Serial number 12. Sandhya Prabhu.
Lord, well, I'm for the respondents.
In this matter,
Lord, matter nenne list number 1 nalliತ್ತು. Reach agilla. My learned friend made a submission, but I was not there. That association itself is not functioning because of this writ petition.
I then argue the matter and finish it.
Association is functioning, meeting ಆಗ್ತಾ ಇದೆ, ಎಲ್ಲ ಆಗ್ತಾ ಇದೆ. Not such kind of submission should not be made.
Thank you.
The counsel for respond number 2, Bar Council. Ritesh, you are appearing. Whether respond number 5 to 32 are lawyers enrolled with the Bar
Please,
Council?
I'm furnishing the details.
Whether they have cleared the AIB exams and whether they have completed the COP.
For the instructions of the authority committee, my lord, they have completed the AIB exam, and some of them are not applicable because the AIBs came to existence in the year 2011, and some of the respondents are got enrolled in 1980 to 2000, prior to 2012, my lord.
What about respond number 15?
15, we have didn't get the enrollment number. Within 2 days, we will get it, my lord.
Respond number 16.
And 16 and the
Statement
20.
appears to be incorrect because earlier, respond number 16, Vinay Suvarna, they say cleared, but whereas the information given to us, they say it is not clear earlier.
Who gave the information?
Same Karnataka State Bar Council only.
In the added information kodtira.
Allah. My lord, the serial number 16, the candidate who has completed his AIB exam on 30/11/2025. 20th AIB, they have represented and
As on
passed.
the date of election.
Mr. Arnoldi is saying that the information, where is that information that they have given you in writing?
This is filed on, colleague has filed along with a memo on 31st July.
31st July.
We have to see, my lord, as on the date of election. Subsequent clearance is of no.
31st July 26, sir.
At page.
Idya namali?
Ilva. ಇದೆಯಾ? Last page.
Alphabetical.
Serial number
Vinaya, this is
39.
Vinaya Suvarna.
39.
AB cleared antiದೆ. COP no.
Serial number 39.
Correct. A status as
clear.
on
AIB status on 6/11/25.
no, she has taken up the AIB on 20th AIB she has taken.
Please, ma'am.
So as on the date that this information was given, she had not cleared it. As on the date that this is being filed, she has cleared it.
Yeah.
Subsequent.
Exam results were pending. Is what we can make out.
As on the date of election,
AIB cleared ಅಂತಿದೆ. Date of the election ನೋಡ್ಬೇಕು.
but ಇದರಲ್ಲಿ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ they say AIB status as on 6/11/25. Election date of 6/11.
Yes, now you have received this.
Yes, sir.
Ready for your submissions?
Lord, my submission is the voters list is there, Lord, at page. The one which your lordship just now saw is a list of voters. Last time your lordship said directed that the respondents, details of the respondents to be given. Now nearly 41 voters, maybe out of that, my lord, one or two have cleared. That is about 39 voters have not cleared, and they are included in the voters list.
The last time the submission was made only as regards respond number 5 to 32.
Yeah. That is the last direction.
Now to say 39 and Tagala, 5 to 32.
39 voters. The respondents, blood, are elected office bearers, different office bearers. The question was whether the office bearers themselves had not cleared the examination was the issue. So in that regard, only Vinay Suvarna has not cleared it as on the date of election. But the entire voters list includes the name of 39 voters.
If you had mentioned it last time, we would have asked them to give the details.
Last time not.
There's a piecemeal ಅಲ್ಲಿ
ಅದೇ ವೋಟರ್ಸ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಯಾಕೆಂದ್ರೆ
The memo is filed.
the question is whether the selection voters list is a defective voters list or otherwise. That is the main issue.
Last time your lordship said, with regard to not these office bearers, we furnish the details from the bar council. And with regard to 41 members, they are not parties before this honorable court. They are not been. Therefore, not only with regard to these respondents, I will look into this.
Correct.
With regard to other aspects, the lordship said will raise.
There was no submission made. Only people who are parties only we can look at.
Yes, that's yes.
No, but we are not seeking any relief against the voters.
You are asking them to be disenfranchised.
No, they have to necessarily, depends upon whether I need not make all of them a party. The question is whether the electoral roll is defective or not.
Yeah, you file a civil suit.
I am not seeking for inclusion or exclusion. I am only saying that the election held by this on the basis of this electoral roll or defective electoral roll has to be set aside.
So for that purpose, we don't need to consider whether they are eligible or not.
Because every voter need not be heard, my lord. This is not a case of where we are seeking for setting aside any elected office bearer.
See, the only reason why we are entertaining this petition is because it's an advocate association. We have clearly, categorically said that. If there's any other society, we would have just sent it to the civil court. Only to see that, because both of us are part of the same two wheels of the same bicycle, we have to travel together properly, and there should be a decorum maintained at both the places, and everything to be done properly and ashte. Technically hodre now hodre problem agutte. We can't go technically. Just trying to see if things have been done properly.
Election held on the basis of a defective voters list, Supreme Court has held in one case that such an election cannot be sustained.
Correct. For a society, you will have to file a suit. Supreme Court has held that. Full bench of the Madras High Court has held that.
Against Advocates Association is maintainable is the view already taken by Justice Vishwanath Chetty in the case of Bangalore.
That has been changed also by the division bench. Division bench has held otherwise. We are only trying to see if some kind of a arrangement could be brought about so that all of you can go together properly. Because election to a bar council is not election to any other office. There is no There's nothing in this except for,
What is there in the office, we don't know, but
we
it is
presume that
what-
there's nothing apart from representing the noble profession. That is what we presume. If there's something else, we don't know. That is why we are trying to bring about all of you together. There should not be, Mane Nagmangla bantu, Nagmangla close aitu. People did resolve the matters. It's not proper for advocates to be fighting. Technically, then go to the civil court. It is a fact finding.
Yeah, ultimately, my lord, we go by what your lordships.
You are, in this matter, it is not adversarial. You are appearing as a senior counsel, we'll
I understand.
regard it not as you appearing for the party in this matter. In other matters, it is completely different. That you know. Idralli, please look at what it is. All of you are there. You're also appearing as president.
President, I was elected. And my team is also elected.
Who are you?
I'm not an adversary, my lord. I only wish to say this should not be.
Three senior counsels are
I'm
there.
not-
Mr. Hegde is more competent.
I'm in the middle, my lord.
Hegde is more competent to
Bar
suggest.
council member.
Bar council
Only want
member.
to say, any information in the bar council we have already furnished, my lord, but whatever the information.
Try and resolve these things.
Please.
I think
We will
PP
resolve it. I'm not in
Hegde
any
should
party.
think of suggesting some solution. He's from the same area.
ನೀವ್ ಹೇಳಿದ್ ಕೇಳಕ್ಕೆ ನೀವ್ ಹೇಳಿದ್ದು ಎಲ್ರೂ ಕೇಳ್ತಾರೆ ಯಾರು ಕೇಳಲ್ಲ.
Can I make one suggestion? Can I make one banner? As a president, we committed a mistake, but I was the president. As of now, I'm the president. I have also represented the office of Spirit. Out of 800 and odd members, 39 voters did not they clear the AB examination. The Bar Council of India even recently said those persons who are not clear the AB examinations cannot either contest or vote in the election. So this is an admitted position.
Mr. Basraj, what we have been
Therefore,
only
as a president, I am saying we have committed a mistake. I do not mind fresh elections. That's all I'm saying. That's all I'm saying.
maybe
Nothing
it
more than that.
maybe it suits you now.
Yes. No, it doesn't.
Not-
suit me. For another 3 years I'm there. Why should I lose the election?
Please, as advocates, don't wash your dirty linen in public. Don't do that.
I'm already elected for another 3
No,
years.
no,
What I'm
don't-
saying is there is a
ಇನ್ನೇನ್
defect.
ಹೇಳಕ್ಕಾಗಲ್ಲ ನಿಮ್ಗೆ.
Pure. That's all I'm saying.
If you want to wash, please wash.
My learned friend, respondent number 7, he is the president now. He was the president earlier, on the earlier term. He was the general secretary previous term. They are the person who prepared this voter list, my lord. They did not take any NOC from the other candidate, whether they have passed the examination or not. These are the persons. Now, the only problem is the respondent number 7, the president, where he does not have the majority. Entire 18 members are on one side, no 6 members are the other side. Therefore, my lord, he has set up the petitioners to file the suit, and also one OS original suit by the respondent number 16, who has not cleared the exam and takes an injunction order against the functioning of the association. Respondent number 16 and for the respondent number 7, the petitioner has appeared before in the suit.
From where we sit, it's a little different.
No, sir.
Where do you sit, Mr. Hegde? So what do you want to do about it?
I would rather suggest, my lords, some senior members there, my lords, senior committee, they can call both sides and my humble suggestion.
You take the lead.
Please,
You take the lead.
request the senior committee, very, very good advocates, senior advocates are there, my lords. We will request them on board.
Not,
This is not, I humbly submit, this is not a way. This is not a come to- And especially from the coastal belt, man, we don't, advocates don't come to courts. It's only litigants who come to courts. Usually, there's no litigation in the bar, my lords.
Some three
And
senior
most of the-
advocates, some three senior advocates, they can be called upon to mediate.
give us their names. You decide amongst yourselves.
Hegde knows more about whatever he suggests.
We'll have it on Monday. You let us know. You can discuss amongst yourselves.
Please, we'll speak to both sides.
What is to be done?
And also the concern, because some of the, I am told, senior advocates don't want to be. We will request them. This is.
The order in this is very simple. Go to the civil court. all these are disputed question, we can't look at it. And that is what the full bench of the Madras High Court has said. Why we are only asking you to resolve, we have told you already.
No, we bow down to my lords.
ಬೇರೆಯವ್ರಿಗೂ ಹೇಳ್ತೀವಿ, ಅವ್ರು ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಓಕೆ ಅಂತ ಬಿಟ್ಬಿಡ್ತೀವಿ. ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಹೇಳ್ಬೋದು. That's all.
Bow down ಅಂದ್ರೆ ಏನ್
Bow down to the view.
What we don't.
Not outside. No, I'm going to only that side, but not to either side.
Mr. Arnoldi hatra loaded statement will come in a very plain language with the same tone. Don't worry.
It's already loaded. We don't know when he will shoot my lord.
Is one person will not get ruffled by anything.
Always loaded.
ಏನಾದ್ರು ಮಾಡಿ please try and
Monday 2:30.
Monday 2:30. At the request of all the councils, relist on Monday at 2:30 p.m.
Great.
4:30 hour.
Serial number.
Sorry.
Correction, the
One-
survey number.
Is serial number 20. Kiran was to argue.
Yes, my lord. This is 4:30, my lord. He's here.
When will you do it? You're done, no?
Serial number 50.
No, we are supposed to argue. Balance for 15 minutes.
Balance 15 minutes.
Lord, but date can be fixed where I'll commence, my lord, soon after Rajesh completes. My lord.
Thursday we'll see.
Thursday.
20 is released on 20th. At
That's a
2:30.
28.
Serial number
20.
50, you are on. 50, you are
28th
on.
is Sunday. No, Saturday.
50.
20th. Yes.
Serial number 50.
50.
Half hearing made your honor. Passover made
ಅದು ಇದು senior citizen ಅಲ್ಲ. ಅದು released on 20th.
Serial number.
Preliminary hearing.
That is one serial number 51. I'm appearing as a parking person.
Yes.
I'll be just 1 minute. For submission.
Not now. If I give you 1 minute, everybody will want 30 seconds. So it's not possible.
Serial number.
I filed a
That's good.
petition for.
Yes, Mr.
13 minutes. 13 monthly, the next matter actually. In this.
Next matter.
It is, your lordship had already allowed the writ petition directing the executive officer, my lord, to allow me puja rights. Since I'm no longer the executive officer, I'm now called the secretary, Chamundeshwari Temple Trust, and therefore there's no order against me. I will not comply.
Which matter is it?
The puja, the priest had vitiligo.
Vitiligo, yes.
Now she's still not preventing. She's prevented me completely. For last
Who
1
is
month,
preventing you?
her name is Rupa Manor, who's the secretary of
Mr.
Chamundeshwari
Jaffer.
Development Authority.
Have it tomorrow.
Yes, my lord.
If this prevented after an order being passed by this court,
We'll check out the instruction.
one last chance for to.
Yes.
Otherwise, we'll only initiate criminal contempt.
We'll check out the instruction.
Umpteen number of excuses have already been given. He has been suffering for so many years. Can't be perpetuating this injustice again.
No, my lord.
13 released tomorrow at 2:30.
Your lordship, serial number 18, list number 2, your lordship.
Huh?
Serial number 18, list number 2.
Huh?
IA for correction has been filed to survey number, your lordship.
Yes,
Better
Vinay. We'll allow that application.
That may be allowed, your lordship.
IA 2 of 25. IA 1 of 26 has been filed for amendment of IA 1 of 25 on the ground that there
May
was
not be
typographical
one.
error in the mentioning of the survey number. Accepting the reasons stated in support of IA 1 of 26, the amendment application is allowed. Counsel for the petitioner is permitted to amend the IA number 1 of 25,
Please.
replacing the survey number. Consequently, IA 2 of 26 would have to be allowed to amend the portion of the order. Now, this one we'll have to hear you because they'll require some changes to be made.
And order on IA 1 of,
ಅದು ನೋಡ್ಬೇಕಾಗತ್ತೆ ಮಿಸ್ಟರ್ released on 24th. First amendment carry out.
being spoken to, your lordship. Kindly listen, being spoken because dispose of matter actually.
Serial number 16.
There's a IA, so being spoken to ಬರಲ್ಲ. ನೀವು ಹಿಂಗೆ ಹೇಳಿದ್ರೆ.
230.
Yes, Mr. Ariga?
Yes.
230, your lordship, 230.
30.
Serial number 11 passed over.
11 of first list. It'll repeat tomorrow.
Yes.
Yes,
Serial number 17, first list.
70.
First list.
Yen urgent en.
Veluru Vakaliga Singh, the election matter from last 5 years.
Vakaligar Sangha.
No election.
70.
ಹೌದು.
70 release tomorrow at 2:30. Yen ella election. Why are all the advocates fighting?
My lords. My lords,
Where is
serial
Mr. Hegde?
numbers.
ಅವ್ರಿಗೆ ಇನ್ನೂ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ಬೇಕು.
My lords, if I may mention.
Yes, madam.
My lords, serial number 94. This is it's listed today at serial number 94. It's regarding the students matter regarding where ISC has suspended her, my lords, after the ICASH proceedings. Respondent has not yet filed their objection. Can it be listed, my lords, any day tomorrow?
Speak on date.
Serial number 60. Serial number 60 is a direction to the IOC to take over the petrol from my scheduled property.
We can't pass orders and mentioning.
It's a representation that we are given. They have vacated the property.
Dates.
My lord, serial number 82. My lord, serial number 82, my lords. My lord, serial number 82, my lords. There is urgency.
Past overs ella nale tomorrow. Past overs tomorrow. List 1 remaining matters 10th.
Ma'am, idu serial number
10th September.
Madam, idu serial number 94, and then I just mentioned it. Huh? I had just mentioned it. It's an urgency.
Madam, I have some difficulty. 27th August, first week of September. Serial number 19.
19 yeah, date ಹೇಳಿ sir. Date ಹೇಳಿ.
Your objection not taken. September
first week I'll go.
Date ಹೇಳಿ sir.
September 2nd or 3rd.
ಆಯ್ತು. ಸೆಕೆಂಡ್ ಮಾಡ್ಲಾ sir?
Please. ಹಾಕೋದಾ sir? Interim order may be explained. Thank you.
ಅಲ್ಲ ಎಲ್ಲ 10th ಸೆಪ್ಟೆಂಬರ್ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇಲ್ಲ.
Madam, idu 94 seat.
14% ಒಂದು ಸ್ವಲ್ಪ ರಿಪೋರ್ಟ್ ಕೊಡಿ.
Madam, idu 94. Serial number 94 I had mentioned.
ಅಲ್ಲ ಈ ಪೇಪರ್ ಸೇಮಿ ಕೊಡ್ತೀರಾ ಬೇಡ? ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್? ಬೇಡ, ಕೌಂಟ್ರಲ್ ಫೈಲ್ ಮಾಡಿ. ನನಗೆ ಬೇಡ. ಕೌಂಟ್ರಲ್ ಫೈಲ್ ಮಾಡಿ. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ, ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಆಗುತ್ತೆ. ರೀಚ್ ಆಗ್ಲಿಲ್ವಲ್ಲ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ನೀವು ಕೌಂಟ್ರಲ್ ಫೈಲ್ ಮಾಡಿ. ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 12 ಹೌದು, ಅದು ಕೆಪ್ಪಿಲೋ ಆಯ್ತು. ಫೈಲಲ್ಲಿದೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 27th August. ಫಸ್ಟ್ ಲಿಸ್ಟ್ 10th September. ಫಾಸ್ಟ್ ಅವರ್ಸ್ ನಾಳೆ.
Madam, serial number 94, I mentioned there's an urgency.
27th August.
Okay. Thank you.
ನನಗೆ ಹೇಳಿರೋದು ನಾನು ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ನಾಳೆ ಬಂದು ಏನಾದ್ರು ಮಾಡ್ತೀನಿ. 10th September ನೀವು ಬೆಳಗ್ಗೆ ಬಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾವ ಡೇಟಿಗೆ ಬೇಕೋ ಆ ಡೇಟಿಗೆ. ಅಲ್ಲ, ನಾನು ಕೊಡೋದು 10th September. 14% ಇದಾರ ನಿಮ್ ಕೇಸಲ್ಲಿ? 16 ಆಗಿದ್ರೆ ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡಿರ್ತಾರ, ಅವ್ರು ಮಾಡ್ತಾರೆ. ಏನ್ ಹೇಳಿದ್ರು? ಡೇಟ್ ಕೊಡಿ 10th September. ಹೇಳಿರೋದು ಆ ಡೇಟು ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್. 10th September 12 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಲ್ಲ ನಾಳೆ, ಅಲಾಂಗ್ ವಿತ್ 93 ಎಲ್ಲ ಅದೇ ಡೇಟ್ಸ್. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದು ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾರಿಗೆ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. 14% ಸೀರಿಯಲ್ ನಂಬರ್ 51 ನಾಳೆ. ಇನ್ನು ಹತ್ರ ಇದ್ರಿ ಇವತ್ತು ಅಲ್ವಾ? ಯಾವ್ದು ಬೇಡ, 2:30 ಬೇಡ. ನಾಳೆ ಬೇರೆ ಲಿಸ್ಟ್ ಇದೆ 2:30ಗೆ ಆಗ್ಬೋದು. ಇನ್ನೊಂದು 10 ಫೈಲು ಸರಿ ಇರ್ಲಿ, ರೀಚ್ ಆಗ್ಬೇಕಲ್ವಾ? ಅದೇ 10th September ಎಲ್ಲ ಮ್ಯಾಟ್ರು ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಬೆಳಗ್ಗೆ ಮೆಮೊ ತಗೊಂಬನ್ನಿ. ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಯಾರಿಗ್ ಬೇಕು ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ನೀವು ಮಾಡಿ ಬಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿ. ಸ್ಯಾಟರ್ಡೆ ಇರುತ್ತೋ ಇಲ್ವೋ ಅನ್ನೋದು ನಂಗೆ ಗೊತ್ತಾಗಲ್ಲ ಆಮೇಲೆ ಅಲ್ವಾ, ಗೊತ್ತಾಗುತ್ತೆ ನೀವು ಮೆಮೊ ಕೊಟ್ಟಾಗ ಗೊತ್ತಾಗುತ್ತೆ. ಇಲ್ಲ ಫಾಸ್ಟ್ ಅವರ್ಸ್ ಎಲ್ಲ ನಾಳೆ ಹೇಳಿರೋದು ನಾನು ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. 19 ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲ, ಅವ್ರ ಡೇಟ್ ಕೇಳಿದ್ರು 2 ಸೆಪ್ಟೆಂಬರಿಗೆ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬಂದಿದ್ದರು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರು 16 ಅದೇನಾ ಡಿಸ್ಮಿಸ್ಡ್ ಅದು ಅದೇ ತಾನೆ, ಡಿಸ್ಮಿಸ್ಡ್ ಅದು ಎಲ್ಲ 10. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೆಮೊ ತಗೊಂಡ್ಬನ್ನಿ. 10 ಸೆಪ್ಟೆಂಬರ್ ನಂಗೆ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ನಾನು ಅದನ್ನೇ ಮಾಡೋದು. ನಾಳೆ ಬಂದು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. 84 ಅದೇ 10 ಸೆಪ್ಟೆಂಬರ್. ಜಾಸ್ತಿ ಬೇಕಾ? ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಮಾಡೋಣ, ಕಮ್ಮಿ ಇಲ್ಲ. ಯಾವ್ದದು?
ಮೇಡಮ್
84 ಯಾವತ್ತು?
ಮೇಡಮ್
18th ಇಬ್ರು ಯಾವ್ದು ಸೀರಿಯಲ್? 84 84 ಅದರ್ ಸೈಡ್ ಇದಾರಾ? ಅಲ್ಲ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಡೇಟ್ ಹೇಳಿದಾಗ ಯಾವ್ದು ಕೊಡೋದು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ, ಅದಕ್ಕೆ ಯಾವ್ದು? 18th ಸೆಪ್ಟೆಂಬರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 81 ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ಲಾಂಗ್. ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ
81 ಲಾಂಗ್ ಡೇಟ್ ಹೇಳಿ ನೀವೇ, ಒಂದು ಡೇಟ್ ಹೇಳಿ. 5th ಅಕ್ಟೋಬರ್. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಮೇಡಮ್. 73
47
47 ಪಾಸ್ ಓವರ್ ನಾಳೆ.
ಪಾಸ್ ಓವರ್ ಆಗುತ್ತೆ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಜಸ್ಟ್ ಫೋನ್ ಮಾಡಿದ್ರು.
47 ಪಾಸ್ ಓವರ್ ನಾಳೆ. ಪಾಸ್ ಓವರ್ಸ್ ನಾಳೆ. 73 72 10th ಸೆಪ್ಟೆಂಬರ್. 73 10 ಸೆಪ್ಟೆಂಬರ್. 10 ಸೆಪ್ಟೆಂಬರ್ 70 ನಾಳೆ. ನೀವೆಲ್ಲಿದ್ದೀರಾ? ನೀವಿಲ್ವಲ್ಲ. 70 ನಾಳೆ ಆದ್ರೆ ನೀವಿಲ್ಲ. ಯಾವ 72 10 ಸೆಪ್ಟೆಂಬರ್ ನಾಳೆ ಅಲ್ಲ. ಪಾಸ್ಟ್ ಅವರ್ಸ್ ಎಲ್ಲ ನಾಳೆ ಹೇಳಿದ್ದಾರೆ. ನಾಳೆ ಬಂತು ಏನ್ ಬೇಕು. ಈಗ ನಾಳೆ ಬಂದು ಮೆಮೊ ತಗೊಂಡ್ಬನ್ನಿ, ಯಾವ ಡೇಟಿಗೆ ಬೇಕು ತಗೊಳ್ಳಿ. ಒಂದ್ಸತಿ ಹೇಳಿದ್ಮೇಲೆ ನಿಲ್ಲಿಸ್ಕೊಳ್ಳಿ ಸಾಕು. ನೀವಿಬ್ರು ಬೇರೆ ಬೇರೆ ಡೇಟ್ ಹೇಳಿದ್ರೆ ನಾನು ನನ್ನ ಡೇಟೇ ಹಾಕೋದು. 10 ಸೆಪ್ಟೆಂಬರ್. ಆಮೇಲೆ ಬಂದು ಇನ್ ಸ್ವಲ್ಪ ಹೊತ್ತು ಇದೊಂದು ಹೇಳ್ಬೇಡಿ, ಯಾವತ್ತು ರೀಚ್ ಆಗಲ್ಲ. ಶಾರ್ಟ್ ಅಲ್ಲ, ಜಾಸ್ತಿ ಬೇಕಾದ್ರೆ ಕೇಳಿ. ನೋಡಿ ಇವರೆಲ್ಲ ಕೇಳ್ತಿದ್ದಾರೆ, ಜಾಸ್ತಿ ಕೊಡ್ತೀನಿ, ಕಮ್ಮಿ ಇಲ್ಲ. ಹ 24th ಅಕ್ಟೋಬರ್ 5th. 68 ನಿಮ್ದೆ. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಯಾವುದು? 82 ಯಾವತ್ತು? ಒಂದೇನಾ ಸೇಮ್? ಯಾವತ್ತು? ಅಲ್ಲ ನೀವ್ ಹೇಳ್ಬೇಕು. ಕಾಯೋರ್ ನೀವು, ರೀಚ್ ಆಗಲ್ಲ, ಕಾಯ್ಬೇಕು. ಅದಕ್ಕೆ ಕಾಯೋರ್ ನೀವು, ನೀವೇ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಇರಿ ಒಂದ್ ನಿಮಿಷ ಅವ್ರದ್ದು ಆಗ್ಬಿಡ್ಲಿ. 25/8 ನಿಮ್ದು. 81 ಅಲ್ಲ, ಅವ್ರು ಯಾರೋ 5th ಅಕ್ಟೋಬರ್ ಕೇಳಿದ್ರಲ್ಲಪ್ಪ. ನೀವ್ಯಾರು? 4. ಇವ್ರು ಯಾರು ಲಾಂಗ್ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಅಂದ್ರಲ್ಲ. 10 ಸೆಪ್ಟೆಂಬರ್ ಇರ್ಲಿ, ಯಾವ್ದು ಬೇಡ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಅವ್ರೊಂದ್ ಡೇಟ್ ನೀವೊಂದ್ ಡೇಟ್ ಹೇಳ್ತಿದ್ರ. ಅವ್ರು ಆಗ್ಲೇ 5th ಅಕ್ಟೋಬರ್ ಜಾಸ್ತಿ ಕೊಡಿ ಅಂತ ತಗೊಂಡು, ಇವ್ರೆ ಪಿಟಿಷನರೇ ಕೇಳಿದ್ರಲ್ಲ. ಇವಾಗ ಅಲ್ಲಿದ್ರು, ಆ ಕಡೆ ಇದ್ರು. ಈಗ 10 ಸೆಪ್ಟೆಂಬರ್ ಮಾಡ್ತೀನಿ, ನಾನು ಡೇಟ್ ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ. ನಾಳೆ ನಿಮ್ದು ಸರ್ ರೀಚ್ ಆಗುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ನಾಳಿದ್ದಿಲ್ಲ, ನಾಳೆ. ಪಾಸ್ ಓವರ್ ನಿಮ್ ಪಾಸ್ ಓವರ್ ಅಲ್ವಾ? ಪಾಸ್ ಓವರ್ ಆಗ್ಲಿಲ್ವಾ? ಅಯ್ಯೋ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ನಿಮ್ಮದು ನಾಳೆ ಬರ್ತಿತ್ತೆ, ನೀವು ಡೇಟ್ ತಗೊಂಡ್ಬಿಟ್ರಾ? 24th ಮಂಡೇ. ಮಂಡೇ 24 50 20ಅಂತೆಪ್ಪ. ಬರ್ತೀರಾ? ಹಾ, ನಾಳಿದ್ದು. ಸರಿ ಹೋಗ್ಲಿ ಬಿಡಿ, ಈಗ ನಾಳಿದ್ದು ಬನ್ನಿ. ನಾಳಿದ್ದು ಬನ್ನಿ. 63 ಹೇಳಿ. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ? ಯಾವತ್ತು? 12 ಸೆಪ್ಟೆಂಬರ್. 11 ರಜಾನಾ? ಇಲ್ಲ. ಅದು ಮಂಡೇ ಬಂದ್ಮೇಲೆ ಗೊತ್ತಾಗೋದು, ಅಲ್ಲಿವರೆಗೂ ಗೊತ್ತಾಗಲ್ಲ. ನನಗ್ ಗೊತ್ತಿಲ್ಲ. ಅಯ್ಯೋ, ನಂಗೆ ಗೊತ್ತಿಲ್ವಲ್ಲ, ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ನನಗ್ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಕಾಯ್ಬೇಕು. ಇಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ಇರುತ್ತೆ, ನಿಮ್ ಫೋನಲ್ಲಿ ಬರ್ತಾ ಇರುತ್ತೆ, ನೋಡ್ತಾ ಇರ್ಬೋದು. ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. ಇಲ್ಲ, ಬೇಡ ಬೇಡ ಬೇಡ, ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಕೇಳ್ಬೇಡಿ. ಯಾವುದು? 10 ಸೆಪ್ಟೆಂಬರ್ ನಾನ್ ಕೊಡೋ ಡೇಟ್ ಅದು, ಅದಕ್ಕೆ. ಅಲ್ಲ, ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಬೇಡ, ಚಾನ್ಸ್ ತಗೋಬೇಡಿ, ಬೇಡ. ಅಲ್ಲ, ಈಗ ನಾನು ಮಾಡೋದನ್ನ ಮಾಡ್ತೀನಿ, ಆಗ್ದಿರಾ ಇರೋದೆಲ್ಲ ನೀವ್ ಹೇಳಿದ್ರೆ ನಾನು ಹೆಂಗ್ ಮಾಡ್ಲಿ ಹೇಳಿ? 10th ಕೆಲವ್ರು ಹಿಂಗೆ ಡೇಟ್ ಕೇಳ್ತಾರೆ. ಹೇಳಿ, ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ? ಕೂತ್ಕೊಂಡು ಓಡೋಗ್ಬಿಡ್ತಾರೆ ಮನೆಗೆ. ಇರಲ್ವಲ್ಲ ಸೀಟಲ್ಲಿ. ನಾನ್ ಬರ್ಕೊಡು ಅಂತಂದ್ರೆ ಮಾಡಲ್ಲ. ಅಲ್ಲ, ನೀವು ನಿಮ್ ತೊಂದ್ರೆ ಹೇಳ್ತೀರಾ, ನಾನ್ ನನ್ ತೊಂದ್ರೆ ಹೇಳ. ಒಂದೊಂದ್ ಫೈಲ್ 2 ನಿಮಿಷ ಆಗುತ್ತೆ. ಕೂತ್ಕೊಂಡು ನಾನ್ ಮಾಡಿ ಹೋಗ್ತೀನಿ. ಬರೆಯಕ್ ಹೇಳಿ, ಹೋಗ್ತಾರೆ ಮನೆಗೆ. ನೀವ್ ಹೇಳಿದೀರಾ ಅವ್ರಿಗೆ, ಅವ್ರು ಮಾಡ್ತಿಲ್ಲ. ನೀವ್ ಅವ್ರಿಗೆ ಹೇಳಿದೀರಾ ಅಲ್ವಾ? ಅಷ್ಟೇ, ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ. ನಾನು ದಿನ ಹೇಳ್ತೀನಿ, ಬರೆಯಲ್ಲ, ಓಡೋಗ್ಬಿಡ್ತಾರೆ. ನಾನೇನ್ ಮಾಡ್ಲಿ? ನಾನೊಬ್ಳೆ ಯಾಕೆ 8 ಗಂಟೆವರೆಗೂ ಇರ್ಬೇಕು ದಿನ? ಅಷ್ಟೇ. ನಾನು ಅವ್ರ ದಿನ ಹೇಳ್ತಾನೆ ಇದ್ದೀನಿ, ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಅಂತ.